You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
The Florida Supreme Court is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen of the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Crane versus the state of Florida.
Good morning, Mr. Chief Justice. Robert Strain from Tampa, representing Mr. Crane. If it please the court, the presentation of our post-conviction evidence and argument today is rather simple and straightforward, largely due to our failed attempts to find some new evidence, if you will, from the post-conviction DNA testing by which the post-conviction court, who was also the trial court, found that we met the requirements of the new Rule 3853. The bottom line is
But could
that
you just, as you were introducing, did you say there was more DNA testing?
in post-conviction, oh, yes,
Yes.
ma'am, over strong state objections, I might add.
And did that confirm what was presented at trial?
We struck out on every single item that went down, and everything.
When you
that
say strikeout, let's just make sure we're here. Of course, our interest is that this has been a fair and just result, and that
Right.
so it confirms, the DNA confirms that it was a mixture of both.
No, ma'am. The results of the post-conviction laboratory testing was no results. They did not obtain any DNA either through degradation or
Any additional DNA?
they had no results from any of the tests that they performed.
Well, so, but you don't, that doesn't, does that cast down on the original evidence?
No, ma'am, and we've never argued
Okay,
that.
all right.
It's just partly relevant, if I may just have one moment on that. The post-conviction court, as you may recall in its order, considered the reliability of the two DNA experts who testified, and he, if you will, critiqued our expert, Dr. Brown, for speculation. Well, he did not point out in his order, but the record reflects the reason she was speculating at the post-conviction hearing because of the no results from the post-conviction lab tests.
But that doesn't, that's, all right, so, but the point is that on your blood, you've made 2 points directed to the 2 pieces of physical evidence, one on the blood and one on the scratches. And on the blood, my concern is that in this case, there was a stipulation that it was blood, and the defense lawyers hired their own private or confidential expert, and they made a strategic decision, informed strategic decision, to stipulate that it was blood because Mr. Crane had talked about how blood got there based on his knowledge that there was blood found. And so you've got to get past, first of all, why that wasn't a reasonable strategic decision, and then even if you do, you'd have to show that there was prejudice, that is, that you'd be able to establish at a new trial that it probably wasn't blood.
Well, I disagree on 2 main parts of what you just related to me, Justice Periante. Mr. Crane never knew there was blood found as part of the state's evidence because no one, meaning the state or defense, was ever given a conclusive test showing that the speck of reddish brown material found on the toilet seat or the DNA material found on the boxer shorts was blood.
Okay, I
She
understand.
testified that she had a tooth problem and that the tooth was loose and it was bleeding. I mean, he testified about how there was possibly blood in his bathroom, correct?
Well, by the time of the trial, Mr. Crane certainly knew. But if you analyzed the the defense counsel's testimony about why they stipulated, and here, this is the thrust, and it's a simple thrust, but a powerful thrust of our argument. As to their stipulation of the DNA evidence, by them stipulating to it being blood, they prevented the jury from having an explanation of alternate sources of that DNA.
But I guess what I'm asking, let's go back to this, not that he testified at trial about it, but he talked to the news media after the trial, after he was arrested or at some point before trial, and talked about how she had a loose tooth and there was bleeding, because, and that's what the defense lawyers were faced with. Is that not true, that he did talk about a reason there would be blood in his bathroom?
The issue was always raised.
I'm asking you a direct question. I don't understand. Yes, did he talk to the news media about a reason that there would...
Yes, he did.
Let me finish my question.
Oh, I'm sorry.
That there was a reason why, an innocent reason why there would be blood found in his bathroom.
In those in the pre-trial media interviews, the word blood wasn't a focus. It was explaining what he was doing with the child and his context with the child.
And what did it have to do with the loose tooth?
Yes, ma'am.
And that he gave her a tissue? Is that, yes? About that he gave her a tissue?
Yes.
And what would he be talking about that for, if not to explain why there was evidence found in his bathroom?
But Justice Pariente, your questioning ignores the fact that, and let me present the thrust of our argument. When that DNA speck from the speck on the toilet seat and the DNA from the boxer shorts was stipulated as blood, it enabled the state to run with its theory that there was a bloody encounter in terms of the victim's death at the hands of Mr. Crane, and it prevented the jury from understanding the way the post-conviction record emphasized.
Help me understand what's going on here. As I understood it, the challenge was that this was some kind of substrata test that was presumptively blood. Is that correct?
That's right.
And these defense lawyers, I thought, had discussions. They had an expert, and the expert could not undermine the findings of the state at that time. Isn't that correct?
That's correct, Justice Lewis.
Okay. And the experts again came on, even during post-conviction, and said, we know of no requirement to do thus and so, that what happened was done appropriately, properly, and therefore there are no standards violated. There was nothing to attack.
Well,
was that part of the testimony?
Well, with one caveat, Dr. Yeshin, the state's examiner, in his words, when he was working at FDLE before the trial, he said it was a shortcut for him to do the presumptive testing and send that evidence straight and convert or move it over to the DNA testing without the conclusive testing.
So I'm wrong then when I understand that this record post-conviction the evidence would support that they did not violate any standards or anything at FDLE, that this is the way that it was done at that time. So I'm incorrect on that then.
No, you're correct on that, Justice Lewis.
Okay.
But again, here's the thrust, folks. This court was not unanimous in terms of the extrapolation of limited physical evidence in this case. The direct appeal opinion of this court raises very unique questions about the circumstantial evidence being sufficient to show the conviction and of kidnapping or the felony murder with that component of the kidnapping and then the death sentence. That little speck of reddish brown material on the toilet got extrapolated to blood because defense counsel felt it would not be prejudicial. And certainly they didn't.
Are you suggesting then if there was mucus that belonged to this little girl on his underwear, that changes the story?
Well, here's the thing.
Wait, is that what you're saying? That this was, whether it's mucus, blood, some other secretion, it did belong to this child. Is that correct?
The DNA did, Justice Lewis, but there's no testing for mucus or blood at the DNA lab, and that's the emphasis. And
okay, so you're saying that there was no DNA of this child on the underwear?
No, I never said that, Justice Lewis.
Is that the case? Is that what the evidence is?
There is DNA, we don't, but the key of our case is we don't know where that DNA came from
because it was the child's DNA.
It was a child's DNA.
There's no question in this case that the DNA that was found was this child's DNA.
That's correct, and then we've never argued elsewise.
Let me do this for you, because you're getting down in your time. I think your argument on the scratch marks, I'd like you to spend a little time on that, because I am concerned about Dr. Vega's testimony and what your new expert was able to say. So could you please
Sure,
explain whether the state ran with something with Dr. Vega that the court picked up on? Looks like we did not even accurately state Dr. Vega's testimony in the direct appeal opinion, and use that in order to show further evidence of a struggle. Tell me the significant difference in terms of your expert, Dr. Wright, and how this would have influenced the outcome of this case if you had had your own expert as opposed to cross-examining Dr. Vega.
Well, and I start by acknowledging, Justice Periante, that there are no cases that say you have to have an expert whenever the state brings an expert. But that also...
I just want you to, let's get over whether they should have hired one. I want to know if they had one, like Dr. Wright.
Well, again,
what are the significant differences between what Dr. Wright said and what Dr. Vega said?
Dr. Wright analyzed the same 20-some photographs that Dr. Vega did. 18 of them, he expressed his opinion that they just could not and never should have been alluded to as possible scratches from a human, let alone a young child.
And how did that differ? So 18 of the 20 were positively, in his view, excluded as being scratch marks coming from a child or a human being.
That's correct.
What did Dr. Vega say about those same 18?
Well, he went to,
Scratch marks.
it was only, I believe the actual number, not only the two that Dr. Wright acknowledged as possibly scratch marks from a human, but Dr. Vega said, and in each case, recall that there were two, I believe there were two others that he alluded to as possible scratch marks, but then he conceded they were all the scratch marks were consistent with injuries that a crabber could have with crab traps and wiring and all that. But one of the key features of Dr. Wright's analysis, and he had his experience in Broward County and elsewhere included over 14,000 autopsies, I believe. He said there were only 2 or 3 cases where a scratch mark would not be curvicular, I believe is the term, the way most people trim their nails. And the only exceptions were a few homicide victims who had scratch marks from what the police theory were witch cases. In other words, 2 or 3 times in his long career did he get exposed to anybody filing their fingernails down into points as little weapons. And so our argument about the scratches is, goodness sake, when you read the prosecutor's closing argument, the blood and the scratches, how this court ran with that picture
Okay, so
that the state
if
gave.
you had an expert, are you suggesting that this should have been Fry tested? That the evidence shouldn't have come in at all on the scratch marks?
No, and again, Justice Periante, I'm not trying to delude the court in saying this was a case where we have monumental case precedent that says every examiner in a no-body case has to have another pathologist testifying against them. We recognize that because even Dr. Wright's acknowledged, as you know, that Dr. Vega's written report that became part of the record, he didn't have any disagreements with that.
But the bottom line here, let me see if I can understand what the bottom line is here, and that is that both Dr. Wright and Dr. Vega acknowledged that some of these were in fact possibly human scratch marks. Is that correct?
2 for Dr. Wright.
And
remotely possible. The adjectives he used were very unlikely. And again, he was explaining.
So why do you have him saying that there was?
Wait, excuse me a minute. He said all but 2 scratch marks. He didn't say 2 scratch marks, all but 2.
No, I believe Dr. Wright's testimony was that only 2 were possibly caused by humans.
No, I think it's the other way around.
Well, let me, so how do we get to him also saying that he essentially found nothing wrong with the written report that Dr. Vega did? I mean, the 2 seem to be inconsistent to me.
And that's where I need to emphasize to you the reasons trial counsel gave for the blood stipulation is they determined before trial it would not be prejudicial. The reason they gave for not retaining their own pathologist to counteract Dr. Vega's testimony is they thought that, by their handling of Dr. Vega on cross, that scratch testimony would not be damaging.
Well, wasn't there...
If I may, Justice Quince, I'm sorry to interrupt you, but those two explanations for why this court extrapolated from the state's closing argument of a bloody struggle proven or shown by scratches on Mr. Crane's arm is just wrong and it's ineffective. And if the jury had heard from an expert how many other sources of DNA could have gotten on that toilet seat or their boxer shorts, if the jury had heard from an expert how...
But didn't this expert, didn't Dr. Vega have to acknowledge during his testimony that although he believed that some of these were human scratch marks, that all of these marks were consistent with anything that could have caused a scratching? Didn't he have to acknowledge that during the cross-examination?
That's right, and I started talking about the scratch marks, acknowledging there are no cases in Mr. Crane's favor that insists to have their own expert counter the other.
Mr. Strain, you can continue. I just want you to know you're down to 3 minutes total.
One last thing. When you go to the law library and read how to be an effective trial counsel, criminal or civil, the books and articles are legion on the battle of the experts and how risky it is in any type of case for a lawyer to rely solely on their cross-examination, no matter how good it is. And we just feel, and we urge this court to see how building one inference to the other from the blood and the scratches as the only possible ways to uphold the felony murder conviction with the kidnapping with intent to harm has to be seen as entirely different today than at the time of direct appeal.
Good morning, Scott Brown on behalf of the state of Florida. As to the state,
I just would like to go right to the heart of something that concerns me greatly, and it involves why nobody brought this to the court's attention before. In the direct appeal opinion, it says, although the pathologist could not identify the source of the scratches with certainty, he testified that all but 2 of the scratches were more likely to be caused by the fingernails of a 7-year-old than by another cause. Now, Dr. Wright says only 2 of the scratches cannot be excluded. It looks like we either misunderstood Dr. Vega's testimony, or that's a significant difference. And rereading Dr. Vega's testimony, it looks like we misunderstood what he was saying. What is it, Mr. Brown? Did we miss it?
Sure.
Is that correct? Is that statement that the pathologist could not identify the sources of the scratches with certainty, but he testified all but 2 of the scratches were more likely to be caused by the fingernails of a 7-year-old than by another cause?
he did say likely. Some of the scratches were more likely. I don't believe he said all but 2. But he did say that the spacing on some of the scratches were consistent with the spaces between what you would find on a 7-year-old child. But the key is this case, the state made those favorable arguments, and this court made those favorable inferences on appeal.
But what I'm concerned about, frankly, is I read Dr. Wright, and it's very clear to me that the following is correct. First of all, Dr. Vega testified that these were all made within 24 hours or a day or 2. Correct. Very significant evidence for the jury, I would assume, and then he also testified that positively that within a reasonable degree of medical certainty that these scratches, he could not say they were caused by fingernails. He said, or that there was no reasonable degree of medical certainty. And then he said only 2 of the scratches couldn't be excluded at all. I find that to be very different then whatever Dr. Vega was saying and whatever the state was trying to infer from it. And the reason it's important in this case is there's no question that there is enough evidence, in my view, to convict Mr. Crane of murder. The issue is first-degree murder, and the issue there is the underlying felony, as Mrs. Strain pointed out, is felony murder, kidnapping with intent to commit bodily harm. The court appears in its analysis to have focused on the blood, but also on the scratch marks. Is it your view that without the scratch marks, let's just say, let's take the scratch marks out, that there is enough evidence to sustain kidnapping with intent to commit bodily harm in this case?
Absolutely, Your Honor.
Okay, well, tell us why.
That was just one piece of a very big puzzle that painted an unmistakable picture of Mr. Crane as the one who took Amanda Brown from the bed where she lay sleeping with her mother, took her back to his trailer. And we know that Amanda was back in his trailer because we have 3 items with her blood on it. 2 were a mixture. One speck was Amanda's on the toilet seat, and we have 1 drop of blood of Amanda's on Mr. Crane's boxer shorts. So we know that she was taken back after being in Mr. Crane's trailer earlier that day to his trailer. There's not an innocent explanation for the state's blood evidence in this case. She was taken without consent back to his trailer. The evidence showed conclusively that they were both bleeding at that time. And remember, this is just a small piece of evidence, and I could be up here half an hour telling you each piece of evidence. His bathroom lit up like a Christmas tree with bleach. It reeked of bleach. He cleaned up a much larger blood spill in the bathroom. But the key point is those spots of blood that Mr. Crane missed establish that Amanda was bleeding and Mr. Crane was bleeding. Both medical examiners testified that those scratch marks were inflicted within 24 hours.
I thought Dr. Wright said that wasn't the case.
No, in fact, he agreed exactly with Dr. Vega that most of those scratch marks were very recent. You can't tell within the hour, but they were certainly recent injuries. So there's not a point of contention there. This claim comes to this court as an ineffective assistance of counsel claim. Dennis Hernandez was an experienced trial attorney, had 200 felony jury trials, 15 first-degree murder cases. He deposed Dr. Vega and determined reasonably, as a tactical decision, that he could handle his testimony on cross-examination.
Did the record does reflect, does it not, that the defense counsel had confidential experts, just didn't use them on the DNA issue?
Correct. He hired Dr. Bill William Shields on the blood and DNA evidence.
Okay, so he did hire an expert.
Indeed, yes.
Did that expert have access? It's my understanding that the expert had access to the information about the DNA?
Yes, Your Honor.
Is that established?
Correct. Absolutely, Dr. Shields. There's never been any question either that Dr. Shields, and again, that doesn't necessarily go to the scratch mark. That's more the DNA. I understand. But if I can go back briefly, Your Honor, to the scratch mark evidence. The interesting thing here is the defendant's post-conviction expert, Dr. Wright, agreed that the defense attorney brought out the nature of and the limitations of the state expert's testimony. He said...
I'm more concerned that this court appears to have given the testimony greater weight than now looking at what Dr. Wright said than I would think. That's, again, in other words, if we concluded something that made that scratch marks evidence more significant, then it's a certainly logical thing that the jury may have. And listen, we've all been trial lawyers, and yes, you can do a job on cross-examination, but to really get the jury's attention, having your own expert give direct testimony, when that evidence, it's important evidence. Now, I understand we're here not second-guessing, but did the defense lawyer, was he asked whether he considered hiring a confidential expert to relook at the scratch marks to see whether Dr. Vega's testimony could be significantly impeached? And this idea again that all but 2 of the scratch marks were actually excluded as being from a human being, to me, is pretty significant as far as the scratch marks themselves.
Your Honor, I think you're overstating Dr. Wright's post-conviction testimony. He testified on cross-examination that he could not rule out the possibility that these scratch marks, all of them, were made by the fingernails of a 7-year-old girl. That's in the record. I believe I quoted his testimony. He couldn't rule it out, and he did agree that at least 2 of the scratch marks were mildly suggestive of fingernail scratches from a 7-year-old girl. So if you add Dr. Wright to the mix, the state is still going to argue the favorable inferences from Dr. Vega, and now he's got a defense expert saying, you know what, he agrees that these 2 are mildly suggestive of scratch marks from a 7-year-old girl. So you've got confirmation, if you will, albeit the defense would argue weak confirmation, from a defense expert. And again, you have the fact that Mr. Crane is bleeding in his bathroom and Amanda is bleeding in his bathroom. Again, that blood was not there. Catherine Hartman testified that Amanda was not bleeding. She used Mr. Crane's bathroom once. There was no blood. There was something around the bottom of the toilet. There were no clothes on the back of the toilet. Again, Amanda was taken back to Mr. Crane's trailer, and she is bleeding, and Mr. Crane is bleeding.
Well, let me just ask you another question about the scratch marks. The state argued in its closing argument a couple of things. First of all, that when he was asked about the scratch marks, Mr. Crane, that he said it came from crabbing. And then when the police officer asked for him to explain how that happened, he became defensive.
Correct, Your Honor.
So that testimony could still come in.
Exactly.
Then the other question is that the state also argued about the location of the scratch marks. Now, we don't have the photographs up here. I checked. I guess the photographic exhibits don't come back up. But what is it about? Was there something about where the scratch marks were and that they were only in a certain place versus that might also exclude that they came from somebody who would be crabbing? In other words, there was something about where they are in the arms.
Well, Your Honor, also, Mr. Crane was very evasive. When he said, I'll get these crabbing, well, pulling up traps and whatnot. Well, show me how you would do that. How would that happen? He became immediately evasive. So again, that is a favorable inference that the state will argue. But Mr. Crane, his boat's equipped with a winch to pull up the crab traps. And he never really posited an explanation for all of those scratch marks. So again, if you look at the totality of the circumstances here, you still have Dr. Vega's testimony.
The question that you ask is about the location of the scratches.
Correct.
Can you read anything from that?
Well, Dr. Wright attempted to. He tried to state that the location of these scratch marks were inconsistent with what he would expect.
What is that location? I think that's part of the question is, where were all of these scratch marks located?
He had some on both arms, but forearm and some of the back going on up. And I wish I could read you the exhibit. I know 2 of the exhibits that were more likely to be caused by fingernails were exhibit 34 and 32. I understand this court doesn't have the photographs. I'm sure we can obtain those.
But they were not on his legs. They were not on his back. No. You're saying all of these scratch marks were on his arms.
The ones that we argued were that were consistent with him attacking Amanda. And again, the reasonable inferences can be made and argued from this evidence. And they still would be, given the post-conviction testimony of Dr. Wright. Again, this very experienced trial attorney, after deposing the defense expert, indicated that I'm going to handle this on cross-examination. This court's cases indicate that a defense attorney may, in fact, rely upon cross-examination rather than hire his own expert if you bring out the nature of the limitations of the state
and I
expert's
appreciate
testimony.
that. And in almost every case, I agree with you. My concern here is that because this was a circumstantial evidence case, because you have one Justice Wells, who dissented and didn't even think there was enough evidence to sustain the conviction, the court spent a lot of time looking at all the pieces of the evidence. And then the issue was, because there was, it was a general verdict, we focused on the kidnapping. And then because, we could speculate that he brought this, little girl back and had either sex or sexually abused her, and then got panicked and, killed her after that. But we don't know that. We have no evidence. That would be speculation. So you now have to go to the evidence of what might have happened. As you said, but for there being the blood in the bathroom, You'd be really, yes, he took her, but then what happened from when he took her to when she's killed?
Well-
We don't know that. How do you know, how are you able to establish that he intended to commit bodily harm from the blood and then the scratch marks? Now, that's why those two bits of physical evidence become more important in this case than they were if there was an eyewitness, Mr. Crane had, given a confession. This would be almost irrelevant. But that's why it becomes so important. So I think you've explained how you think it didn't, even without the scratch marks, there's enough evidence that he took her, that there was a struggle, that there was blood without the scratch marks. I'm just focusing on the fact that the court made a big deal about the scratch marks.
And Your Honor, again, I think directly on point is this court's opinion in Branch v. State. There, in post-conviction, they brought in two experts, and this court said, hey, look, the prosecutor introduced this evidence, but the defense counsel brought out the nature and limitations of the testimony. This testimony, and the interesting thing about this case is Dr. Wright agreed that the defense attorney did an effective job on cross-examination, because the defense attorney elicited that from the state expert, Dr. Vega, that he could not conclude to a reasonable degree of medical certainty that any one particular implement or instrument or hands caused those scratch marks. So
He also couldn't say that it was more likely to be caused by the fingernails more likely. That, to me, talks in terms of some probability, not possibility. And yet Dr. Wright is saying, no, it's not a possibility. If it's anything as to these two scratch marks, it's a remote possibility. That's qualitatively different. You're not going to convince me otherwise that that's not qualitatively different.
You're making a leap that this Dr. Wright was more credible, first of all, than Dr. Vega. I don't think this court would make that leap. And secondly, the favorable
where is that?
inferences.
Did the judge evaluate Dr. Wright's testimony and find him not to be credible?
He indicated that these experienced, no, he didn't even reach that point.
Then what are we supposed to do with that?
Well, you look at Dr. Vega's testimony. I think you don't even need to get to the prejudice prong, because this is a very experienced defense attorney who highlighted the weaknesses, if any, or limitations of the experts. Now, if you find that trial counsel, this very experienced trial attorney, was ineffective for not hiring his own expert, then you have articulated essentially a per se rule that, hey, you can't rely on cross-examination.
Don't you think somebody should have called to the court's attention that what was said on direct appeal on a motion for rehearing was not 100% correct?
I'm not entirely sure, Your Honor. I don't know that is, frankly, what this court said was incorrect. I think there were favorable arguments and inferences that are made, and the state is entitled to on a motion for judgment of acquittal. If I may get to the blood evidence issue.
I am going to ask one more thing. Did he testify that all but two of the scratches were more likely to be caused by the fingernail of a 7-year-old than by another cause? Did Dr. Vega testify to that?
I don't believe all of the, and again, I have to go back and look at it, Your Honor. I did review it, believe it or not, but prior to it. But he did say many were, and some of it was based on the spacing. I didn't know if he said all but two, but many were likely. But he also said they could have been crab traps and debris.
But Dr. Wright said clearly he said the exact opposite. He said only two cannot be excluded.
You know what? You're overstating his testimony. He said at the end of his testimony, I can't rule out that these were in fact caused by fingernails. He said it was unlikely, but he couldn't rule it out either. So he's really speculating. So you're taking this defense expert, Dr. Wright, who does testify almost entirely for the defense now in his post-medical examiner career, and saying everything he said was gospel. Well, what he said was the defense attorney brought out the nature of and limitations of Dr. Vega's opinion on cross-examination, and he said there was nothing unprofessional about Dr. Vega's opinion in this case. So that's what Dr. Wright said. And again, if I can briefly, I know I'm running short on time, on the blood evidence, as mentioned before, the experienced trial attorneys here looked at challenging the blood evidence. They hired a reasonable expert whose qualifications has not been challenged, Dr. Shields. They looked at challenging it, but Mr. Crane had an innocent explanation for the blood, that she had a loose potentially bleeding tooth. And even now, after the post-conviction hearing, Dr. Johnson, who the post-conviction court stated much of her testimony was based on speculation. I would submit that all of her testimony was based on speculation. That reddish-brown material that looked like blood, reacted like blood, and yielded DNA results like blood was in fact blood. And Dr. Ted Yeshon, the state expert who testified during the post-conviction hearing, discounted the possibility of a false positive reading. And let me clear up one thing that Mr. Strain said. There were some DNA results obtained in 2007 by Reliagene, the defense lab, and they were on Mr. Crane's boxer shorts, the same boxer shorts that had Amanda's blood on them. They found sperm cells, and they were matched to Mr. Crane. So there were some subsequent DNA test results. Now, the substrate control testing that was done did not yield anything, and Dr. Yeshon thought that it was not because of degradation, but because those adjacent areas did not have any DNA, because obviously those shorts yielded DNA results. So again, with that point of clarification, these highly experienced defense attorneys offered a theory at trial to explain away the state's DNA evidence. And they went with that rather than a weak, speculative attack upon the state's DNA and blood evidence.
And I just want to make sure, I think Mr. Strain alluded to it, in all of the post-conviction, there's no evidence that there's another explanation for Amanda Brown's disappearance, for all the other evidence that points to Mr. Crane as being the
Absolutely not, Your Honor. And this court didn't even mention all of the evidence in direct appeal opinion. Again, some of the most compelling evidence is the way he had 4 hours to be alone with Amanda, dispose of her body, and then 2 hours after pulling his boat in and getting the call from Amanda Hartman that Amanda is missing. What does he do? He pulls out on his boat, and he's found 2 hours later. He changed his clothes on the boat. He was wearing dark dress slacks and a maroon shirt, and when he's found, he's wearing jeans and a blue shirt. So he disposed of Amanda and his bloody clothes, but you know what? He left his boxer shorts on, the boxer shorts that contained Amanda's blood. So again, if you look at all the...
That's about 2:30 or 3 o'clock in the morning?
From 2:30, Your Honor, and then he puts his boat in around 6:15, 6:30. And that's when he gets the call, and then he's out 2 hours on the bay before the police can find him. So again,
he's in his dress pants
and a marine dress shirt.
At
Correct.
6:30 in the morning.
To go crabbing, and he changes. He's got something rolled up under his arm, and again, this is a disinterested witness who said that's very strange. You don't see somebody go crabbing like that. He pulled his truck back, all the way back into the front tires were submerged, which is also very unusual. He was in a hurry, Mr. Crane was. Even after getting that call from a frantic mother saying, "Where's Amanda?"
What were both shirts short-sleeved? Do we know?
I believe they both were, the maroon shirt, but it was clearly he changed on the boat, and we've never recovered those clothing items, and we have not recovered Amanda Brown's
Was that
body.
the dress pants and the shirt, was that what he was wearing when he went to sleep that night at the mother's house?
They're similar, but we don't know exactly. There are similar descriptions, but it's absolutely clear that he may have changed twice. Again, but Amanda's blood is found on the boxer shorts that he was wearing when he was found on that boat. And again, if you look at all the evidence in this case, Mr. Crane was defended not by novice attorneys, but 2 of the more experienced defense attorneys in Hillsborough County. They routinely attend life over death seminars. They looked at the state's evidence. They challenged it. They made Mr. Crane's case in court, and we ask that you respectfully affirm the decision of the lower court below. Thank you.
With all due respect, Mr. Brown, I believe he skewered the facts again in his presentation right now. But let me first answer you, Justice Perianti. At post-conviction, defense counsel was specifically asked, did you ever consider hiring your own pathologist to either first review Dr. Vega's materials and then maybe later decide to have him testify or not? Mr. Hernandez answered that quite, again, as I mentioned on direct, that from the day they got Dr. Vega's report, they did not believe the scratch evidence would be damaging, and they never contemplated hiring their own expert. Mr. Brown right now has talked about bloodstains being proven as being cleaned up. I believe he's confused the fact of what time that cell phone call came in when Mr. Crane, I believe, in fact, received it after he was out on the water.
Well, we know about what happened in the bathroom. It's that Mr. Crane said he spilled something and he spent all night cleaning up his bathroom, and then it all lit up with luminol. Now, luminol is so. Those are reasonable inferences. I don't think Mr. Brown was misstating the inference.
But when Mr. Brown says that there's a proper inference that Mr. Crane cleaned up a large blood spill on the floor.
Was that luminol all over the bathroom?
As I understand it, it was a bathroom in a mobile home, and it was rather modest in size. The luminol they spread on the floor, as I understand it, and it lit up. But it lights up both for bleach and
did Mr. Crane say that he spent all night cleaning up his bathroom?
There were, I don't know, that's getting close to his exact description.
And the carpeting in the bathroom was found in a washing machine or dryer?
Well, that was something extra too. But as even defense counsel argued to the jury, there was no other evidence. And recall that this court itself, even in the majority opinion, recognized that it was just an inference upon an inference that Mr. Crane even kidnapped Amanda Brown.
Please don't misrepresent
from the
what we said on direct appeal. It's not an inference upon an inference. There's a whole series.
I apologize for the way I phrased it, but when this court reduced the kidnapping charge to false imprisonment, you were recognizing that the trial court's and state's argument was an inference upon inference about whether or not there was a kidnapping with intent to commit homicide, as opposed to the intent to commit bodily harm. So again, as this court doubly has to be cautious in terms of ruling on what the effect of this stipulation, because defense counsel did not think it would be prejudicial, and the scratch evidence because they did not think Dr. Vega's testimony would be damaging. Thank you for your time.
We thank you both for your argument. I'll move to the second case on our docket, which is Nelson versus the state of Florida.
May it please the court, Your Honor. I'm Baye Harrison, court-appointed counsel for Joshua Nelson. In this particular case, the murder that took place was utterly senseless. And
I'm sorry, would you keep your voice up?
I'm sorry.
Utterly what?
Was senseless. And what caught my attention when I first read your opinion affirming the judgment and sentence, I was very caught by Justice Pariente's concurring thoughts. She said in that opinion, in part, one has only to consider the unemotional, matter-of-fact way that Nelson confessed to the murder on videotape to realize that something in this 18-year-old's life had gone seriously wrong long before he committed the brutal murders in this case. And that brings us to our first point that I'd like to argue here today, which is point 3 in our brief. And that is our claim that the trial court erred in rejecting Nelson's claim that he was denied effective assistance of counsel during the penalty phase because his attorney failed to call his mother and stepfathers as witnesses.
But on that, weren't they there and then took off?
Absolutely, Your Honor.
Well, doesn't that present the defense counsel with a rather difficult situation? And the very fact that they take off would seem to then call into question how well they're going to perform if they're there, if they're somehow compelled to be there.
Your Honor, especially Joshua's mother had made it very clear that she had important exculpatory testimony, or at least mitigating testimony, vis-a-vis
But wouldn't the point I was trying to get to is, wouldn't a reasonable defense attorney confronted with a witness who had absconded reasonably be concerned about the way that witness would perform?
Your Honor, not necessarily, and here's the problem. Defense counsel did not subpoena Joshua's mother. He did not subpoena Mr. Percival. So what happened was, during the guilt-innocence phase, there was an indication that the defense was going to go after Mr. Percival because he had sexually abused Joshua. So
But wasn't that their theory? Wasn't that one of the mitigating circumstances that they were presenting? Because didn't other witnesses, in fact, testify about this abuse?
Yes, Your Honor, you're absolutely right. But I think this may be fair to say that one mother is worth 10 experts on an issue like this.
But this was the mother's husband, correct?
It was the mother's husband, absolutely.
And so when faced with the reality in court, when the defense attorney says, we're going to present evidence to you that says that this stepfather sexually abused this child, the mother and the stepfather then flee the courtroom, as it were. And
Yes, Your Honor, but just having done this for years on the trial level, I can tell you that if a person is under subpoena, and at the beginning of the trial that person is brought into court, and the judge says, now, we're going to invoke the rule, you're under subpoena, you better be here when you're called.
But if you have to subpoena somebody's mother who is facing the death penalty, doesn't that in itself tell you perhaps this is someone I may not want to call because I can't trust her?
Your Honor, there is nothing in the record to indicate that Joshua's mother was going to be anything other than a good mitigating witness until this happened. But again, had she been subpoenaed, that's what normally is done for all witnesses in a capital.
So you subpoena her and make her stay in the courtroom, assuming she wouldn't abscond just because she was subpoenaed. I mean, people do that. So you get her on the stand, and then she doesn't give you the favorable testimony that you thought she was going to give.
Your Honor, that is very speculative. She was Joshua's mother. She never indicated anything other than being there to support him.
But all she had to do was to stay there to support him. She obviously was not going to support him.
If she'd have been,
because she left.
I can tell you, if she'd have been subpoenaed, the defense lawyer could then send the sheriff out to find her.
You know, I think you're hearing what you've been doing this for a long time, but we also have been doing these for a long time. And, as far as the stepfather, I really don't see how putting a stepfather on to say, I abused my son, would have been compelling testimony. What did the mother say at the evidentiary hearing as to why she left?
We were never able to find the mother.
So what are you can't even establish your claim. I mean, in other words, first of all, you can't establish that she would have been available or given favorable testimony. Right?
Okay, I'm not going to beat a dead horse, but
okay.
I don't want to give up on this, all right?
Well, I think if this is your best claim, and listen, this is not a laughing matter. What I said at the time in my concurrence is this is a tragedy. The mental health expert did a very good job of explaining it to the jury. It's just that and he's 18 years old, but with these facts, this is still a proportionate sentence, and I don't. Even and a mother, you say a mother's worth 1,000 other witnesses, but what we know from our cases is that a mother is always going to, except for this time, support her son, and so that's not going to get a lot of credibility. So I think that you cannot unfortunately for you or for Mr. Nelson, be able to demonstrate either deficiency or prejudice on this claim.
Moving on to point 2, then, Your Honor, I hear you.
Is this the tattoo claim that you're
The
getting
tattoo
to now?
claim, the tattoo claim.
Oh,
That's
this is
the one that I find a little more compelling, because my question would, or did you even make the argument that defense attorney, even though this tattooing took place after the guilt phase and before the penalty phase, did the defense attorney ever request that a new jury be seated?
No, and even worse, the defense lawyer, at the conclusion of the guilt-innocence phase, he wasn't prepared to go forward. He wasn't prepared, and he failed to ask the court.
Well, I thought he said.
I'm sorry.
Oh, go on. I thought he said that the reason he wanted this time period is for the jury to sort of cool down or something to that effect, because this trial really had been kind of messy and, you know.
Your Honor, I think he may have said that in part. He also said that he had to get witnesses down from out of state and things of this nature, but at least he could have done minimum. At least he could have asked the judge, Your Honor, would you please instruct the jury? You know, this is a pretty high-profile case. It's not the Bundy case, but it's high profile. Would you please instruct the jury? Make sure you don't read anything, listen to any news accounts. You know, a lot of these local news radio stations were talking about this case. Don't watch television with regard to this particular case.
Well,
So
now,
he
with that
didn't.
tattoo, that is my understanding from the record, and correct me if I'm wrong, but the defense lawyer, that didn't occur at the point of the guilt phase.
No.
It occurred sometime after that, and he didn't even know about it until a day or two before. And then the trial judge, they did interrogate the jurors, did they not?
They did.
And the jurors said that we couldn't even comprehend all the stuff that's going on. So, I mean, there was an interrogation of those jurors. Now, no question, you can always ask for, a new jury panel. But here, did they not make an attempt to see the effect, or if there was an effect, of the post-guilt phase publicity that would impact the jurors so they could not follow the law?
The judge did ask the jurors when they came back after the penalty phase, look, can you be fair? But how in the world can you not take into account something like this? Because
Well, that may be, and I have problems with the law in Florida in some areas where a juror says, I'm so committed, but then they're rehabilitated, so which is true, the first statement or the second? But our law, does it not, as we look at jurors, tell us what we have to do as judges? You're supposed to make sure they'll follow the law and set aside any of their, because everybody walks in there with some kind of background. So isn't that what Florida law requires?
That is, and
that's what this trial judge did?
Yes, sir, and I'm just saying you have to take that with a grain of salt. But you get back to Justice Pariente's question, what in the world compelled this young man to commit such a brutal act on a friend? And Joshua Nelson answered in the jail. He sat there in the jail and he answered the question. Because I'm a natural-born killer.
Well, every time that there's a capital case that comes here, you look at it and say, what in the world were they thinking? I mean, it's just not, we don't believe, I think, in this society that it's a normal thing to brutally murder people.
Exactly.
But you know the number of cases that come through, it does happen.
It does.
And there's not always an explanation that's clear-cut or precise, and this is a young life gone awry.
Right, but all I'm saying is this, if trial counsel had taken action, he could have made sure that those jurors did not know about that natural-born killer business. And here's how it kind of worked out. Now we had a situation where the state has this information. The state's going to put on evidence about this tattoo. So the defense lawyer had to enter into a deal with the prosecutor. If you won't bring up the information about the tattoo, we will not put Joshua Nelson back on the stand during the penalty phase to do. I'm sorry.
Could the state have properly put on evidence about this tattoo and the natural-born killer statement?
The defense lawyer.
Could the state have properly done that? as a part of the penalty phase.
The defense lawyer thought he could, and that's the problem.
And so is your argument that he could not have, and that
No, my argument is by allowing the jurors to learn about this and allowing this to happen, that meant that a deal had to be cut, and what the defense had to give up was something that I think is crucial. What's about the second most important thing you can have in a case like this when you don't have the mom there to testify? At least the defendant can
I
get
thought
up
the defendant did testify.
during the guilt-innocence phase, but he wanted to testify during the penalty phase, and he lost that ability in this deal that they had to cut. And, I mean, these jurors,
But
they...
wasn't
I'm sorry.
there some indication that, I mean, during the guilt phase, it seems to me he testified about a lot of things that really were not that relevant to the guilt phase. But wasn't there some testimony that what he would not have testified to anything differently in the penalty phase than what he testified to in the guilt phase?
Your Honor, that's correct in that he did evince some remorse during his guilt phase testimony.
And part of the remorse, if I'm reading the record correctly, was he was remorseful for the predicament he was in, as well as for the murder he committed. So it's got his double-edged sword. Is that really remorse?
That's a valid argument, but
Okay.
he was...
Well, Ben, didn't he specifically use the word slight feelings of remorse?
Your Honor, that is during the post-conviction phase, and I must
Well, but-
admit
okay,
that's true. You're absolutely right. It is true. When you sit with this young man, he's dead emotionally. That's what he said at the I didn't want him to say that at the post-conviction proceedings, but that's exactly what he said. I'm trying to get the kid to say I was deeply remorseful. That's what I would have said.
Well, what
And
makes
he
you think
says
it would have been
slightly.
any different earlier?
Well,
Why would we think it would be any different earlier?
supposedly, counsel had this kid prepped so that he would make a compelling apology and express sincere
But
remorse.
see, that's
But
where
didn't
I
you have
think-
him prepped too?
Yes, I thought I did. I thought I did.
I mean, don't you think really, Mr. Harrison, that says volumes? Because usually, there's these defendants that think they're not really going to get the death penalty, and so they have an unrealistic view of things. Once they have the death penalty, usually you have, I'll say, just about anything. Here, this defendant, years later, can't even get it up to say, I feel awful. And so we now speculate if he had been called at the penalty phase. I still not, I want to hear this. Okay, he would have said, I really feel badly, but I really hate being in jail. And then the cross-examination would be, let's see, did you, after the guilt phase, did you have a tattoo placed on you? Yes, and what does that say? Natural born killer. And why, Mr. Nelson, did you have that tattoo put on? What did Mr. Nelson say about why he had the tattoo put on?
He just said that it took away some of the boredom. He was very, very matter of fact about all of that.
That's what he said in post-conviction.
Right, but
So just imagine the impact that would have had on the jury. The movie had just come out, Natural Born Killers?
it had been out for a little bit, yes.
I mean, now you'd have to start to say, what is the jury going to be thinking? That image of Natural Born Killers, it's one of the most devastating movies. So he put himself, not only did he put himself in the predicament of killing the person that he killed, an innocent life, but he put himself in the predicament of boxing in the defense lawyer not to be able to call him. It's his doing.
To some extent, it is, but Your Honor, again, if you could just, and I think you can, if you could just try to understand, this kid has no emotions. But let me do this.
But I guess the bottom line is here, how can we really fault trial counsel for not foreseeing that he was going to get a tattoo like that and create this problem? That just seems to be really holding trial counsel to a pretty high standard.
It is, but it's not a high standard to expect counsel to say, hey, Judge, we're going to have a 3-week layover here. Would you please tell the jury, don't read anything about the case? That's done by everybody.
Right now, I just want to let you know you're down to your 4 minutes.
All right. I wanted to get to point 4, but I will just wait until my rebuttal.
What-
I hope Carol mentions that.
You need to discuss it some before.
Well,
You need to deal with it now.
I think counsel is going to address it from the AG's office, so I think I'll be all right. Thank you.
Okay.
Good morning, Your Honors. May it please the Court. I'm Carol Dittmar from the Attorney General's office in Tampa. I don't want to disappoint Mr. Harrison, but I wasn't intending to focus on issue 4 at all. I will be happy to address issues 2 and 3 that have been discussed about this morning. First, as far as issue 3 with the presentation of the mother and the boyfriend, a couple of things I did want to point out was that counsel testified at the evidentiary hearing and post-conviction that he did not request any kind of continuance to try to find the mother and the stepfather when they disappeared, because he was concerned at that point that they would not testify favorably to the defense in light of the circumstances. So he did have that concern once they had taken off. Before that time, the mother had been cooperative.
Was there anything proffered or testified to by anyone that the mother and stepfather would have said anything different from what the other witnesses said about the abuse of the defendant?
To the contrary, the evidence was they would not have anything in addition to what had already been put before the jury. Now, the defense attorney testified that the mother had been cooperative with him, that she knew that he was relying on her to be a defense witness for mitigation purposes. The thing that he recalled, the most valuable thing that he thought she would have added to the penalty phase, was that she recalled having put liquor in Joshua Nelson's bottle when he was a baby. The father, the natural father, did testify at the penalty phase about that exact fact, that when he was colicky as a baby, they put vodka in his bottle. So that was the only specific testimony that the defense attorney recalled he was going to ask the mother about had she been a witness, and the penalty phase jury did hear that testimony from the father. So when the defense attorney was asked in post-conviction, did you have any other information that you intended to bring out that did not come before the jury, he did not have anything. And I believe that Mr. Harrison's investigator also tried to find any other additional information that could have come from the mother.
Yeah, now let me just understand something about the defense attorney was planning to put on both the mother and the stepfather?
What he said about that was he was intending to put on the mother because he knew she had good mitigating things to say. The stepfather, he said, denied the abuse that they had accused him of, and he had no basis to believe that the stepfather had any mitigating testimony at all.
What did he tell the jury?
He was concerned that he was hopeful that the stepfather would come in and come clean, and if he had to look the judge in the eye and was under oath, that he would admit that he actually had been the horrible person that
No, I'm asking you,
Joshua.
what did he tell? Didn't he tell the jury that you're going to hear from the mother and the stepfather?
I don't know that he told him that, because basically what he told him when it came out at guilt phase, it actually came out at the opening statements in the guilt phase of the trial, that they were relying on the fact that Joshua had been sexually abused in his horrible home life, because they were basically making an argument this just wasn't a premeditated murder. I think they were just hoping to get some sympathy from the jury for Joshua Nelson. So he did testify in the guilt phase about his home life, about the sexual abuse, and it was after that he'd made those opening statements in the guilt phase that the mother and the stepfather disappeared.
So he didn't say who would testify to it. He just
said that you'll be hearing about because Joshua did testify to it in the guilt phase.
But and the mother and the stepfather were in the
apparently they were in the courtroom at that time for the opening statement and left right after the opening statement.
They left.
Literally
and they have
left.
never been heard from since.
And
but the opening statement of the guilt phase.
The guilt phase opening statement.
So during the 6
guilt
weeks
phase.
between the guilt phase and the penalty phase, was there any attempt to find the mother?
He said that he looked, and as far as the idea of having them under a subpoena, according to the trial counsel, that would not have made any difference at all. He felt like the mother was completely dominated by the stepfather, and he said, to the extent that he would call home to talk to the mother, and if he called home, it would be the stepfather that called back and kind of was in charge of making sure that the mother was even communicating with the defense attorney. Everything went through the stepfather. So he said that, you know, having her under a subpoena wouldn't have made any difference. Once the stepfather said, we're going to go and we're going to leave, they were, and they wouldn't have stopped because they had a subpoena. That wouldn't have been a reason for them to stop once they heard what was coming out. Now, there was other evidence by some of the other penalty phase witnesses, some of the aunts that testified, that the mother had actually called them and said, don't bother coming and testifying as a penalty phase witness. She's made outrageous statements about this is an election year, they're going to fry him anyway, there's no reason for you to be here. And so the jury actually had that aspect of the mother also, that she not only isn't coming to testify at her own son's penalty phase, she's calling the other witnesses, the father, sisters, and the witnesses that had knowledge of the home life, and telling them, don't come, because they're just trying to make me look like a bad mother. And that all comes out in the penalty phase testimony. So again, the jury heard all that. So there really, I believe that Joshua Nelson testified at the evidentiary hearing that his mother had deceased and was, I don't know how he got that information, or
Had done what?
Had died, was no longer available.
Okay.
At the time of the evidentiary hearing.
I see. Well, whatever it is, I cannot imagine in this case that, because it sounds like the defense lawyer had originally planned to call the mother and the stepfather, that talking about how the mother allowed the state to cross-examine about how the mother did not protect her son from abuse.
Because this had been an extended sexual abuse that had gone on for an extended period of time, and Joshua had consistently, he has said that he went to his mother about it repeatedly, and she was aware of it, and she did not stick up for her son at all, and she allowed it to continue.
The state never tried to, sometimes when at the time of a trial and someone makes an allegation of sexual abuse, the state questions whether it happened. In this case, did the state question whether he had been sexually abused?
Not to my knowledge. I don't think there was any suggestion that was not something that was long-standing at that point.
And they had a psychologist that testified, along
yes,
with
Dr.
all the
Marin.
witness.
Dr. Marin testified extensively about the family dynamics, about Mr. Nelson's mental health. There was another mental health expert at the time of trial, Dr. Borstein, who'd been consulted and who also evaluated Joshua Nelson, but Hal Stevens, the trial attorney, made the decision to put Dr. Marin on as their primary mental health expert at the penalty phase.
And the state, again, didn't really, that wasn't the thrust, that they tried to question the mental health of this defendant.
They did not attempt to rebut anything that Dr. Marin brought forward about his history, his background. Obviously had substance abuse issues. The jury was aware of those. He had some prior mental health counseling that the jury was aware of. So they knew all that. Dr. Marin had all the records available, all the school records, all the medical records.
So here we have almost, it seems like a stellar, for the time, a stellar presentation of mitigation.
I think it was very well investigated. The defense attorney testified at the post-conviction evidentiary hearing. He thought this was the first time in Lee County that a defense attorney had been able to secure funds for a mitigation specialist. And so she put a great package together. There were some issues because the trial judge was not anxious to spend a lot of money doing the mitigation investigation even before the guilt phase, and that was part of the reason that they had the delay, which kind of takes me into the tattoo issue, because Hal Stevens, the trial attorney, testified about, first of all, the delay between the guilt phase and the penalty phase, which he felt was a great advantage for the defense. He felt like they really needed that time. They were still putting their penalty phase case together. They were still trying to locate the defendant's father, who was homeless and lived in the woods in Orlando. They were able to find him. They didn't have him for the guilt phase, but they were able to get him down, and he did testify at the penalty phase. In addition, Hal Stevens talked about how he thought the jury really needed some cooling off period because they had heard incredibly brutal evidence. And as Mr. Harrison said, Joshua Nelson is a very, very cold defendant, and he videotaped basically a reenactment out at the crime scene where he just very coldly outlines everything that happens. And obviously this court, and direct appeal opinion recounts much of his confession, but it certainly made his attorney's job more difficult, made everybody's job more difficult to try to portray him as any sympathetic character to the jury. They had seen that videotape. And so Hal Stevens very much wanted a break from that. He wanted an extended time after the guilt phase, hoping the jury, that some of that would just lessen its impact with having some time in between it and then being able to bring in all the family members and really build up a lot of sympathy for Joshua Nelson. And so that was to his advantage. He obviously did not foresee the defendant going and getting the tattoo. He felt like the worst, everything that could have come out at trial was as bad as it would get, that there would not be anything newsworthy that would happen, so he didn't consider asking the jury to asking the judge to admonish the jury not to read the paper. Now, the judge did tell the jury, don't speak to each other over the break, a few common things like that.
But you do, just as a matter of good policy, and I don't know if we have this in the standard instructions, when you've got such a break between the guilt and the penalty phase, it would seem to be prudent as part of the standard instruction that because there's going to be media about a high-profile murder like this, that you would ask that they do not read the paper. They'd have to do that, wouldn't they?
Well, I think that, you could say that in light of this case. We know that things happen. I think that one thing, you have, almost a whole month, and there are some people who, even jurors, who really are very much want to know what's going on in the world. They don't want to completely remove themselves from the media for that extended period of time. I think, I don't think there's any problem with the judge cautioning them against it when they know there is going to be a break, and this case may be a good reason to say why it's a good reason as a cautionary thing. But
under ordinary circumstances, it would seem to me that any news about this case would have been about the guilt phase, which was already over, but
Well, typically I know there's a lot of concern if, for example, there had been something that had been suppressed, if the confession had been suppressed or there'd been some prejudicial information that didn't come out at trial that the jury didn't hear about that might have been in the press. I think that would have been much more concerning. Hal Stevens testified here, they had heard everything there was to hear. I really didn't think it could get any worse than this. And then he gets up the morning of the penalty phase and reads in the newspaper about the tattoo.
Well, let's go to the legal issue that's involved, and that is whether the trial court, once these events transpired, followed our precedent and what should happen, because there were some of them that mentioned that they had been exposed to that publicity. And do you see Bolin as being the best case, or would you address for us what you see as being the best case for how this was handled, assuming everything went exactly as it did? What?
I'm not sure I can come up with a specific case. There was a full inquiry, and there was, my impression of reading the motion for mistrial is that this also was encompassed. If you look at back in the original trial record, in volume 9 is the motion for mistrial, and they attached, part of it was there'd been prejudicial media information, and they attached the articles to the motion for mistrial. The transcript on that motion is in volume 9 and then volume 10, and the judge agrees at that hearing on the motion for mistrial to question all the jurors about what they had heard, what they'd been exposed to, how it would affect them, how it would impact their decision. And so that inquiry is in volume 10 of the direct appeal record.
So the trial judge followed that approach.
Yes, he did.
That could be, it's not a motion for mistrial. The guilt is already over.
Right. Well, it was basically looking for he wanted to impanel a new jury just for penalty phase.
Oh, okay, well, that's not a mistrial.
So it did encompass some guilt phase mistrial arguments as well. So it was kind of a mixed bag, but the issue was there.
He did ask for a new jury for the penalty phase.
That was my impression on just reading my notes on the motion for mistrial, was that this was part of the argument and certainly was discussed at the hearing on the motion for mistrial. There was also a motion in limine that the defense attorney filed attempting to keep out any evidence of the tattoo. So he filed a motion in limine asking the state to avoid any mention of the tattoo along with a motion for mistrial, and this was discussed. That was a joint hearing on both of those motions. The issue was discussed at that time, and that's when I think the state agreed that they weren't going to bring out the tattoo unless the defendant, Joshua Nelson, took the stand and started testifying to remorse.
Is the standard the same, or is the standard different with regard to jurors being exposed to information about a case pre-trial, start of trial, because that happens from time to time, and what occurred in this case between guilt and penalty? Is there a different standard to be applied? If so, why so? Or if not, why not?
I'm not sure there is a different standard. I think you're looking at whether or not the juror is so impacted by what their own knowledge and what they already know that it's going to have an impact on their decision. And I don't think it matters whether it's the guilt verdict or whether it's a penalty phase recommendation. I think they still need to come up with their decision based on solely on the evidence they've heard from the courtroom and not on any other factor. And that's what they did here. So
the same cases that may have addressed that issue would be applicable in this post-guilt phase posture, is your view.
Right.
But you don't have a case that you would say that would address that absolutely.
I don't off the top of my head, no. That would have been available, obviously, it was all in the direct appeal record.
But I'm looking at the direct appeal. Was any issue raised by defense counsel that the trial court erred in not granting a mistrial or anything about
No, as
this?
part of one of the direct appeal issues, no.
So now the question is, if defense lawyers had done something differently, it would have been what? I'm asking you to help me figure out how.
It couldn't be IAC, I would assume, because
right,
they
I think it would have just been straight up
did exactly what they're complaining about.
Yes,
that's what. Okay,
the trial court
and it
error.
wasn't even obviously the appellate, unless there's a habeas claim. Appellate counsel thought it was handled properly, and it wasn't even a basis to even raise this on appeal.
Well, I think the juror response
correct?
is supports the judge's determination that this jury should go ahead and hear the penalty phase. So there was no basis for concern based on what they were saying at the time.
We don't have a habeas here.
No.
Don't we? Haven't we required that any habeas be filed along with the post-conviction motion?
Yes, it should have been filed if it was going to be filed with the direct appeal, with the initial brief from the post-conviction appeal. Obviously, in this case, there was I believe it was a 100-page direct appeal brief filed by a very experienced public defender who raised both guilt and penalty phase claims. He challenged the finding of HAC. He challenged the finding of CCP. I know there was a DNA issue. There was an issue about the co-defendant statements being admitted in guilt phase. So, I mean, it was I think it was a very thoroughly done appeal where he tried to identify the issues that he really wanted to bring to the court's attention.
Okay,
but
so
we
basically
don't have
what we have is a situation where the trial judge apparently did everything right that was asked for. Defense lawyers tried to actually get a mistrial. It wasn't even, because it was handled right, there was no basis to appeal it.
Right.
And Mr. Nelson essentially did this to himself as far as not being able to take the stand again, but even if he took the stand again, we've got to assume that he wouldn't have testified any more compellingly than he has now, which is basically not compelling at all.
Right, and of course he did tell them when he testified in the guilt phase that he was sorry. So to the extent that he wanted to get that out before the jury, he did. And when he was asked at the post-conviction hearing, well, what would you have said if you had also testified in penalty phase that you didn't already say in guilt phase, he didn't come up with anything. He didn't know of anything to say. So I think where they're looking for deficient performance here is just a failure to to protect the defendant from himself, to prevent something that wasn't really reasonably foreseeable, that this defendant would go out and get this tattoo. So if the court has no further questions, I would ask you to affirm the order entered below denying post-conviction relief. Thank you.
Thank you, Your Honor. Just very briefly, counsel characterizes my comments about Mr. Nelson as him doing things coldly. That was not my intent, if that is what came across. This young man, as the record I think clearly shows, something to his moral structure was stripped away from him at about this time. as a result of his childhood and other problems that he had. It's not that he's malicious, it's just that there's just an absence
What
of
is his
emotion.
mental health status? What did the experts say was his mental deficiency?
Well, Dr. Marin examined him. He found him to be competent. He found him to be sane. And he did suffer from a very, very bad childhood, which included sexual abuse. But you can rest assured, when we got the case, we investigated that issue too, and there was frankly nothing that we could find to.
Because, quite frankly, Mr. Harrison, we see people with these kind of backgrounds all the time in these cases. And often some of these defendants have whatever you call all these letters, HC, DC, or, and they have some other kind of mental illnesses. But this defendant does not seem to have any of that.
No, Your Honor, I agree. He doesn't fall within those categories. But I just, I was asked about what you actually do in a situation like this when we question the effectiveness of counsel. And you've got to play the cards you're dealt. In this particular case, I will agree that Mr. Stevens didn't get a good hand when he took on this case. It was a very, very tough case. I tell you that candidly. But you got to go with the few cards that you have.
Well, he did that, and he got hit. I think having the father who was living in a tent or had moved from a box to a tent must have been pretty, compelling. Certainly better than putting on the stepfather that abused him. So I'm still at a loss to see what else, again, having been dealt the hand that this defense lawyer was dealt, and then you were dealt the hand you're dealt with, it looks to me like there is no way to establish even a scintilla of either deficient performance or prejudice.
Well, I think had his mother testified, had she been subpoenaed, I think there is a good likelihood that she would have been very supportive. Also, if Mr.
But you can't, that is totally based on speculation, since either she's gone or she's really gone. If she's dead, she's certainly gone, and we can't, so it's just speculation.
What would she have said?
I'm sorry, Your Honor.
What would she have said? You're saying that if he had the mother under subpoena, she'd gotten on the stand, what would she have said that would have been so compelling?
She would have confirmed the sexual abuse that the defendant suffered at the hands of Mr. Persifield. And one of the things that could well have happened is if Mr. Persifield had been under subpoena as well, he could have been put up there on the stand, and then if he took the fifth, that would be a great emotional boost for the defendant and give him a shot.
But you see, you look at this record, and there's no counter evidence. I mean, what we have in this record is that the stepfather, in fact, sexually abused this child. And so there's no counter evidence to that, so I'm not sure that I guess it may have been of more impact if the stepfather had actually confessed that he had done it.
He would have either...
Maybe.
Yes, Your Honor. He would have either done that or at least taken the fifth, and I think that would have had a strong impact on the jury. Your Honor, thank you very much. I'm out of time. Thank you.
Okay, we thank you. We thank both sides for your argument. The court will now take a 10-minute recess.
Please rise. Please rise. Florida Supreme Court is now in session. Please be seated.
Now move to the third case on our docket, which is Carbajal versus the state of Florida. Forgive me if I mispronounce that.
That's right, Your Honor. Thank you. Good morning, and may it please the court. My name is Sarah Laluamin from the law firm of Fowler-White Boggs, and I'm here today on behalf of the petitioner, Mr. David Carbajal. This case goes to the very heart of a court's authority to act. Its authority to adjudicate defendants on criminal charges and sentence them, depriving them of life and liberty. This authority is the essence of subject matter jurisdiction. It's not merely procedural, it can't be waived, and it can't be created by the parties or by the court. Rather, it must be expressly granted by the people through the legislature or the Constitution. Based on this paramount nature of subject matter jurisdiction, it's well established that it can be raised anytime by any litigant, by any circumstance, the parties or the court.
Are you arguing that this circuit court did not have subject matter jurisdiction?
Absolutely, Your Honor.
And so this crime was committed where? Where do you contend the crimes that the defendant was convicted of was committed?
The alleged crimes, as conceded by the state, were committed in Lee County. The state concedes on page 18 of the record that the
trial took place where?
In Lee County.
You see, I'm having I accept your proposition that if there is no subject matter jurisdiction, that a judgment may be void and may be raised at any time. In fact, you might even argue the sentence is illegal if it is a void judgment. I'm having trouble with understanding, assuming that the prosecutor should have been the Lee County prosecutor as opposed to the special prosecutor, based on all the case law where a judge from another circuit tries a case and we go, that's maybe voidable, it's not void, or the prosecutor doesn't sign the indictment. And how does that affect the subject matter jurisdiction of the circuit court in Lee County and the jury in Lee County to have heard this case and come up with a valid conviction?
Well, it gets back to the authority, the subject matter jurisdiction of the court and the constitutional underpinnings of that authority. Specifically,
but isn't a prosecutor a prosecutor? In other words, what if the prosecutor had been from Orlando and was on special assignment or something? It seems to me, and I'm not that it's a technical problem. It may have been able to be raised on direct appeal or challenged by way of motion to dismiss, but this defendant chose to plead nolo, and therefore the state didn't have a chance to even, show why this was committed in multiple circuits. So I have, again, I realize you're doing this pro bono, you've made a very good argument, and I appreciate it, and I agree with you in the underlying proposition. I just don't see how in this case, which is I'm sure what you want to do for your client, that it is a void judgment.
It's absolutely a void judgment. This isn't a scenario where there's a technical problem with the case that makes it voidable such that it can be raised on direct appeal or something like that. This is subject matter jurisdiction because it goes to the very authority of the prosecuting officer. In this case, it's the statewide prosecutor that filed that information, and the basis.
But you must recognize that is the authority of the prosecuting authority.
Okay.
Is a question that's distinct from the jurisdiction of the circuit court, and the circuit court has jurisdiction over felonies. This was a felony. I understand that's not really the conflict issue, or there may be more than one conflict issue, as I recall now, but it's not the primary conflict issue, which is this question of whether the time limitations in 3.850 cut off these claims based on a lack of the jurisdiction of the court. But I'm still having trouble, and we'll discuss that, but I'm still having trouble seeing how this is really, what the facts we have here establish that the circuit court was without jurisdiction.
Well, I think really that sounds appealing on its face. These arguments sound very appealing on their face because, of course, it sounds logical. It was, as Justice Quincy mentioned, this was the transactions occurred in Lee County. It was prosecuted in Lee County. That all sounds great, except when we dig deeper and we go to the constitutional basis for the court's jurisdiction, when we go to the constitutional basis for the statewide prosecutor's ability to file an information, we find that ability never occurred in this case. Now, just like this court has recognized...
So I think what Justice Kennedy was just saying is you don't see, it's based on your argument, it seems to me, you don't see a difference between the court's subject matter jurisdiction and the prosecutor's authority to bring a case. You don't see any distinction between those two issues?
Not with respect to the statewide prosecutor, because there are special provisions in the Constitution, in the Florida Constitution, regarding the statewide prosecutor's authority. For example, Article 1, Section 15A of the Constitution provides that the court's authority is triggered by the prosecuting authority. And so that is where we begin the subject matter jurisdiction analysis. And then we move to Article 4, Section 4B, talks about the statewide prosecutor's jurisdiction.
But wouldn't that be more, because let's assume a different set of facts than this, and that a crime actually occurred and the statewide prosecutor is looking at some crimes that ostensibly covered multiple jurisdictions. But in the final analysis, it happened in Orlando. But they were looking at Orlando, Tampa, Polk County, all of this. So the statewide prosecutor in the final analysis, are you saying would not have authority to bring the case because in the final analysis it was just in one county?
If in fact there was only activity in one county, that's correct. But where there's activity in multiple counties, certainly the statewide prosecutor...
But when you say activity, do you mean that the crime itself, or are you talking about things leading up to the crime?
Well, I mean, going back to the constitutional provision, it provides that where the activity occurred, in 2 or more judicial circuits as part of a related transaction. So it doesn't have to necessarily be the one at issue, but there has to have been a related transaction. Now, the state concedes on page 18 of the record that is not the case here. Rather, they proceed under the second, presumably because they've just generally alleged the statewide prosecutor's jurisdiction. They proceed under the second prong, where any such offense is affecting or has affected 2 or more judicial circuits as provided by general law. So it can be where it's affected more than one circuit. And in the case you mentioned, I think, the fear is that you would get through this long case to the end of it, and then you'd find out, oh, in fact, it was just this one. But in the case that you mentioned, it sounded like there would be perhaps an impact on the other.
But doesn't there have to be, I mean, here is somebody who pled nolo, and you have on its face an indictment that alleged criminal activity in more than one county. And I guess what happened here is the drugs were either manufactured in North Carolina, whatever. We don't have, and they were transported down here. The defendant doesn't raise that there's a problem. Are you now saying that in every case involving a statewide prosecutor that you would have the judge inquire of the factual basis for the jurisdiction of the statewide prosecutor? Is that what should be happening? Because otherwise, we put somebody in an untenable position of X number of years later, reconstructing this. And for what purpose? I mean, again, I'm still trying to see. It doesn't affect the fairness of the trial, of the fairness of what happened. Mr. Carbajal, he's not prejudiced, and he doesn't say he would have withdrawn his plea if he had known about this, that the statewide prosecutor couldn't bring it. And if it was brought up, I assume another indictment could have been filed by the Lee County prosecutor to have cured it. That's why I don't see how it's void.
Well, again, I mean, this gets to the appeal of what does it matter? It was Lee County anyway, but...
Well, yes, that's exactly, I'm asking you, how does it matter to Mr. Carbajal? And I'm still not sure I've heard an answer to what Justice Kennedy and Justice Quinn says. How does it matter to the subject matter jurisdiction of the circuit court?
Because the circuit court is given subject matter jurisdiction by the Constitution and by the legislative authority. And the provisions that are at issue here that grant the statewide prosecutor the ability to file an information, that's what gives rise to the court's subject matter jurisdiction. If that statewide prosecutor never had jurisdiction to do that in the first place, and it's clear here that they didn't,
It is clear?
It is clear. It is
so
clear
you
from the
would
record.
you were not even asking that this go back for an evidentiary hearing? You just say that he should be discharged? Is that it?
Your Honor,
is that is that what you're asking?
Primarily, that's what we would request. But secondarily, if this court finds an evidentiary hearing is necessary, we would request that it be remanded for that. Here's why it's not necessary, though,
well,
because
so he's gonna get discharged here. If he had raised this in a timely way, then the proper prosecutorial authority could have brought it. So he can game the system by waiting for this inordinate period of time when the statute of limitations is run. I guess that's your position, and he therefore should be discharged. How in the world could that be equitable? Forgive me for asking so bluntly.
it's not a question of equity, Your Honor, and I would like to address this question that's been asked a few times about when the state has the chance to put this evidence on. And because he pled, they didn't have the chance. Well, they absolutely have the chance. It's always an issue. Jurisdiction is always an issue. A trial court always has to know that they have authority to be doing what they're doing. It's not a question of does this have to be done at trial or, before a plea. From the very beginning, a trial court has to be confident it has authority to do what it's doing. And I think part of the problem in addressing
the court has jurisdiction, did it not? The court has subject matter jurisdiction.
The court did not have jurisdiction because
they didn't have subject matter jurisdiction?
No, Your Honor. That jurisdiction was never invoked because it was attempted to be invoked by the statewide prosecutor, and the statewide prosecutor had no basis. Now, what appears to have happened here, and the reason that I say it's clear on the record, is because they concede that this is not where we have more than one circuit where there's a related action or related transaction taking place, rather that it's affecting more than one. And they argue that because there's out-of-state activity, that somehow is tantamount to multi-circuit activity. In fact, they equate the two in their response to the motion for post-conviction relief. Now, that's certainly not the case, and we don't even know, there's certainly no evidence about how it would have traveled. It's about, the narcotics would have allegedly come from...
What is the, share with me what you see as the legal problem or legal fallacy with the following. A circuit court has jurisdiction, subject matter jurisdiction by Constitution to adjudicate felonies. You agree to that point?
I agree.
Cases must come to the court on some written piece of paper, and many times there may be defects in that piece of paper. Not signed, improper something. Does that affect subject matter jurisdiction or just jurisdiction with regard to that person and those papers?
Well, I unequivocally...
Why would that not be the right analysis? Go ahead.
I unequivocally agreed with you, and perhaps that's a little premature because, yes, the courts have jurisdiction over felonies. However, under Article 1, Section 15 of the Florida Constitution, that has to be invoked. That doesn't just appear. A court doesn't just get a felony and be able to decide it from anywhere in the world. It's got to be appropriate in that court.
Based on what?
Based on the provisions in the Constitution.
Well, but then how is it actually done? Some piece of paper is filed.
Yes, and information.
And if there is a problem with that piece of paper,
If there's a problem...
Don't we generally talk about that as possibly jurisdiction over this case, not subject matter jurisdiction, but jurisdiction in this particular case?
Your Honor, I think the cases that you may be referring to are the cases where there was a defect in the information and that defect was later cured. Now, that's the supplemental authority that the state has brought to this court's attention is one of those cases. There was a defect perhaps in the information, or maybe the information was vague as to the circuits involved, but ultimately there was evidence put on the record of multi-circuit activity.
Well, because maybe it was... Somebody's got to raise the question that there's something wrong before there's going to be evidence. What if, and I'd ask the state this question, what if it was found out after he was prosecuted in Lee County that it was, and let's say it was by the prosecutor in Lee County, that they made a mistake and that it was right on the county line and he was actually, the crime occurred in the adjacent county. And they found that out 20 years later. Would that entire, let's say it was for murder, would that entire conviction be void?
If that, I believe in your example, you're not using the statewide prosecutors.
No, I'm using, it was another, the wrong prosecutor, it was prosecuted in, quote, the wrong county.
So I'm not aware of a constitutional provision that goes to, you know, that particular prosecutor's ability to file an information like what we have here with the statewide prosecutor. This is a very special case of the statewide prosecutor. It's grounded in the Constitution. The Constitution has to grant that authority for subject matter jurisdiction to exist. Subject matter jurisdiction never existed here because the statewide prosecutor never had that authority under the Constitution.
Well,
so
could I ask you to address the certified conflict issue and just tell me why we should not read Rule 3.850 according to its plain terms. The rule there specifies that grounds for a motion include the court did not have jurisdiction to impose the sentence. That's listed right there. And then it's got the time limitations with certain exceptions. There's no exception for the kind of circumstance that we have here. Why shouldn't no exception from the time limitation? So why shouldn't the time limitation here apply to this claim of a lack of jurisdiction if we get to this point and agree that the court lacked jurisdiction? I don't, but if we did, and based our analysis on what the second district did, why wouldn't we conclude that the second district was right in reading this rule as it is written?
Well, that's certainly how the rule's written. The question is that rule valid when applied to subject matter jurisdiction? And there are several reasons why this rule can't apply with respect to subject matter jurisdiction. In fact, there are several reasons why it appears subject matter jurisdiction wasn't even contemplated when this rule was created. And as this court has noted before, sometimes rules are promulgated and then there's an adversary proceeding that brings out the unsustainability of a provision in a rule. And that's exactly what we have here. For example, subsection B of the rule provides grounds for extending time limits on its application. Of course, we know if something is jurisdictional, like subject matter jurisdiction, then you can't extend the time limits. It's jurisdictional. Subsection C, the rule says that it doesn't provide relief on grounds that could have or should have been raised in the trial court or on direct appeal. Well, certainly we know subject matter jurisdiction can be raised for the first time on appeal. It can be raised even in an unauthorized motion for rehearing. It can be raised. It can be raised anywhere by anyone.
Why doesn't the Rule 3.190B, which is the motion to dismiss rule, which says that all defenses available to the defendant by plea, etc., and whether the same shall relate to matters of form, substance, formal acquittal, formal jeopardy, or any other defense. So why isn't this a matter of substance that should have been raised under Rule 3.190?
Again, that's a rule created by the court, and so the subject matter jurisdiction, the notion of a court's authority to act in the first instance, a court can't give itself that authority.
But the court, see, this is where, to me, the problem is. Something was filed in the circuit court, which gave, in my estimation, the circuit court jurisdiction. If there was some defect then why not file a motion to dismiss under this rule? Because by filing the piece of paper, it seems to me the court had jurisdiction unless there's some problem with it that should have been brought to them.
Well, you're assuming that the information invokes the court's jurisdiction. It doesn't where there's no basis for that information, that
so
allegation.
then the court couldn't even rule on it then? So you're saying a court couldn't even rule on anything filed because you're saying there's no subject matter jurisdiction. You can't even rule on a piece of paper that's filed if there's no subject matter jurisdiction.
Well, certainly, the court never has authority to act. That's why as this court has held, that where there's no subject matter jurisdiction, any actions...
Which case? Yeah, there's no question that subject matter jurisdiction, what you're talking about, civil context, other context, is correct. And I don't think you're anything different. Which case says that these circumstances refer to or are properly part of subject matter jurisdiction?
That
what happened here, that the filing here eliminates subject matter jurisdiction. You keep using those two words because those are magic words.
Yes.
But it seems as though you're using them, but where does that come from? Which case says that this scenario is subject matter jurisdiction?
In the Winter case and the Lugar case that we cited in the briefs, Lugar, for example, the information didn't establish the facts and those facts weren't addressed in the record, so therefore there was no subject matter jurisdiction. That was a case also addressing the statewide prosecutor's jurisdiction. And so that it is a specific scenario because it does go to these constitutional provisions that either give that statewide prosecutor the authority to start this process, this machinery, or not.
You have now exhausted all your time, including your rebuttal time, but we helped you a lot with that. So I will give you 2 additional minutes for rebuttal.
Thank you, Your Honor.
Good morning. May it please the court, my name is Elba Martin and I represent the state of Florida in this case. The state would submit that the conflict cases involved in this case do not conflict with the 2nd District Court of Appeal. None of the cases cited as conflict directly and expressly conflict with the 2nd District Court of Appeal opinion. Addressing the issue of subject matter jurisdiction that Justice Parenti spoke about, in this case, subject matter jurisdiction is not affected by this information.
Well, that's you see what my concern is this. I agree that I cannot see how this is subject matter jurisdiction. I think that's what we've been talking about. But what I am concerned with is the broad language in the 2nd District's opinion that says that if the court doesn't have jurisdiction to enter the judgment, that is, it lacks it, the judgment is void, that it's got to be raised in 2 years. Now, I realize the rule apparently says that, but there's a real issue because we've said in other cases subject matter jurisdiction can be raised at any time. What if this was a case where the element of the crime was, say, he got a life sentence because the victim was under 12 years old, and then it was found out 20 years later that the victim was actually, I guess you'd say that was newly discovered or something. But something, and maybe somebody else can come up with a better hypothetical, but I'm concerned with that broad language. A misdemeanor versus a felony. Justice Quinn's helped me out on that. You know, something that we would say, no, just the ends of justice would not be met if we had a strict bar. Yet in this case, it is clear to me that this is not, probably the state can prove this or did prove it, but if it's not raised, there's not going to be more of a record to establish it. So we kind of have, on one hand, we have conflict because other courts have said the jurisdiction of the statewide prosecutor is subject matter jurisdiction. So they're probably wrong on that. And then on the other, then we've got the 2nd District saying, and even if there's no jurisdiction, it can't be raised. So we've got to, it seems like we've got to straighten this out.
Yeah, yes, I agree. The rule itself is clear in that it gives the exceptions to the 2-year limit. And this court itself promulgated this rule over the years and developed it to address post-conviction issues. Most of the cases that involve these type of subject matter jurisdictional issues, can be raised any time within the trial setting, can be raised any time on direct appeal, but when it comes to post-conviction, they're given 2 years. And the rule is clear.
If this were truly a subject matter jurisdiction case, and we know that the 2 years have passed, is there any other remedy? I mean, what else could a defendant file?
If there's newly discovered evidence, as the example that Judge Parenti gave, then they could fall under, I believe it's one of the exceptions.
But I'm saying they don't fall under anything under Rule 3.850. The 2 years have gone. It isn't something newly discovered. This issue has been out there all this time, just like the issue here. What else? And since we have said that subject matter jurisdiction can be raised at any time, what other vehicle would you have other than a 3.850 motion to assert that right to challenge subject matter jurisdiction?
I believe that the only other perhaps vehicle that there might be out there is habeas relief.
Well, how about 3.800s? Don't we have some 3.800s that you can file any time? Is that not broad enough, the rule, to cover this?
I'm sorry?
The 3.800s, the rules that we have for 3.800s.
Yes.
Attack sentences.
They all have, some of them have limits on them
I
also.
understand, but some of them don't have any.
Right, but they,
If
most of the 3800s.
If a sentence is illegal.
Yeah, and actually 3850 addresses sentencing issues also in one of the exceptions and allows that to be raised at any time.
You're not helping us, okay, because there's a case out of the 3rd District saying that Harris could raise at any time a claim that the trial court revoked his probation after the probationary period expired, at which point the trial court no longer had jurisdiction. In other words, somebody was sentenced to prison for a violation of probation, even though it was clear that the probationary period had expired. Now, that's we could say that's an illegal sentence. The state might say, no, it's not an illegal sentence. But would the state argue in that case that even though the probation period had expired and the judge no longer had jurisdiction to revoke the probation, that it would still be fine for that defendant to stay in prison for an extended period of time, maybe the rest of his life?
No, it would not be fair. It would not be equitable.
But you say that we created a rule that would say, nope, you got to raise that in 2 years, even though the defense lawyer was asleep at the switch. The defendant is mentally retarded, wouldn't know how to raise it, and some young lawyer like the two of you found it for this defendant, that the court system would have shut the door?
Well, I would respond to that is that in that argument, I would say that it was a sentencing issue and that it could be raised at any time. However, the rule itself provides for that to be raised at any time, if it's a maximum sentence or the 3800s, which could be raised at any time. When you look at the
Let me ask you, if I could shift a little bit here to statute of limitations issues. If someone is prosecuted for a crime on which the statute of limitations has run, and they don't raise that, they don't object at the trial, they don't raise it in direct appeal. What's your understanding about what the law is on that? When are they foreclosed? Have they waived that issue if they don't raise it at that point at the trial?
I'm not sure about the rules on statute of limitations, Your Honor, but I would say that when it comes to cases such as these that are raised 5, 10, 15 years after the fact, at the time, most of the time, there's an understanding about jurisdiction. It could be an example of like a county court covering jurisdiction for a circuit court if it was a small place. And when you have things that happen 5, 10, 20 years later, then the evidence that would be out there, the facts, the things that the court would rely on to make some of these types of decisions would be gone. And when it comes to something like statute of limitations, maybe at the time the statute of limitations would not have run. Or there's changes in the laws all the time with the statute of limitations. There was a change in the law with how the Office of the Statewide Prosecutor was supposed to plead this case and the information during this time that he had to file
Justice Kennedy is asking you a very specific question. Okay. Clear, the statute of limitations has run, but nobody thought to raise it. Not a factual dispute. Clear, it ran. Not a county court sitting in for a circuit court. Is that one that can be raised at any time, or if you don't catch it in 2 years, that's it, you're in prison for the rest of your life?
I believe we should follow the clear express language of the rule.
But how about all those cases that say things that can be raised at any time? Void judgments, void, not voidable, void judgments, that is, can be raised at any time.
Well, then the rule itself should allow for that.
Oh, then why, that's...
And the rule does not. The rule, nowhere in the rule.
Then this court, in its wisdom, we need to amend the rule if it's not clear.
But is there another vehicle? That's what is always of interest to me is, while 3.850 may not be the vehicle to raise something, is there another vehicle when there is a clear violation, such as the statute of limitations? Would that fall, as Justice Lewis asked you earlier, under something like 3.800, or is that a habeas kind of issue?
Or manifest injustice of
well, you still have to raise it.
Why isn't it just a waived issue? I mean, there are all kind of issues and all kinds of problems that are waived. All kind of constitutional rights that people waive in trials every day. And the fact that they want to bring it up years later, in most circumstances, they're foreclosed because there's a time to bring these things up. And then there's a time to live with the consequences of having failed to bring it up. And otherwise, we have every case is up for grabs perpetually.
Well, that's why the rule was promulgated, to end that sort of cycle. And when the rule was promulgated, jurisdiction was addressed. It was addressed in the first part in A, saying you can raise this in a post-conviction. But I find it interesting that in the second part, it was not given as part of an exception for the 2-year time limit.
But we see habeas cases. We see what the prisoners do. And they raise defects in indictments, and they raise, I mean, we see hundreds of these a year, and we deny hundreds of them a year. And so this extraordinary circumstance, we haven't seen those at least brought to our attention to where we'd be crying out for it. So let's get back just to this case, though. I want to understand, in the real world of special prosecutors, they allege what they've alleged in their indictment.
Yes, ma'am.
And presumably they, in good faith, think it occurred in more than one circuit. It's not like they're trying to usurp the jurisdiction of the local court. I mean, I don't, and this is a friendly question. I don't see how, either if that's not raised at the time the plea is entered, it's even a defect that could be raised on appeal, and enlighten us about why the petitioner's position is incorrect concerning that this is constitutional, their authority, that if they don't have the authority, then the charging document itself is defective.
Well, the Office of Statewide Prosecution has concurrent jurisdiction with the state attorney's office. If this had not been filed by the Office of the Statewide Prosecutor, it would have been filed by the state attorney. So the concurrent, I believe the big difference is in a lot of these conflict cases that have to do with, let's say, a misdemeanor versus a felony, or the court then losing the appellate court having jurisdiction and the circuit court not having jurisdiction is the exclusivity. The statewide prosecutor and the Office of Statewide Prosecution has concurrent jurisdiction over these types of cases.
But they use, I would like you to respond to their argument that in this particular context, that what the problem is, according to Lugar and the other case she relied on, that this is subject matter jurisdiction, meaning the court has no power to act in any way. There's a difference between having power to act and being wrong, as opposed to the power to even entertain the piece of paper.
Well,
what's wrong with those cases that she relies on?
Well, first of all, Lugar and Winter were actually direct appeals on motions to dismiss.
Well, they still said subject matter jurisdiction. Is that what they said?
The state would disagree that it's subject matter jurisdiction. The authority of a prosecutor, the prosecutor in this case, albeit being the statewide prosecution office, is a duly authorized prosecutor, and a duly authorized prosecutor in Lee County. The defect is not the alleged defect is not a defect that goes to the heart of the actual information itself.
The power of the court to act.
The power of the court to act. The felonies were filed. They're all felonies. They're all day-to-day felonies that get filed every day in every single circuit court throughout the state. And the Office of the Statewide Prosecutor, whether correct or not, I'm not going to get into the merits of it right now, filed it with a good faith understanding that this did affect multiple judicial circuits under its purview.
And so to understand this further, I mean, the statewide prosecutor is there so that if it's occurring in Lee County and Broward, that you don't have Lee and Broward County prosecutors fighting over who should take the case. Statewide prosecutor takes it. It's sort of, it's a stopgap, but here, nobody was trying to
There was none of that. Yes, there was none of that. And also, the Office of Statewide Prosecutor can then decide which venue it feels is more appropriate to bring the case if both the things are occurring in two counties. And in this case, the pass-through of the drugs, the actual information itself, I don't know if you have a copy in your record. The information itself didn't just charge Mr. Carbajal, it charged his cousin, who was the person bringing the drugs in from through the state, from North Carolina, Mexico, I believe Atlanta also. So the further part of the information also goes towards the explaining how this was part of multiple judicial circuits.
You mentioned venue. And so if this case had been that they find out that it went through different counties and they made a decision to bring it in, say, Orange County, and it's later found out that all the acts really occurred in Lee County, would that be subject matter jurisdiction issue or a venue issue, and can that be waived?
Well, venue can be waived. Okay. It's my understanding by the case law that venue can be waived, and that venue is also something that it needs to be brought in the 2-year time limit of the 3850.
Well, I don't even know why would venue, this is to me where it's a pretty big difference between something that doesn't affect the fairness of what happens to this defendant, which is he committed a drug crime, he pled guilty or nolo, and he has a sentence that is an appropriate sentence. My concern is more with the defendant, again, whose the probation has elapsed, and so that we don't create a broad rule. So I don't see.
Well, it's very narrow. This kind of case is very narrow, I believe. And the Office of Statewide Prosecutor, in filing this information, obviously did so on a good faith basis, believing that it had the jurisdiction to file it in this court. The facts of the case, be it as they may, would be affected if this was brought 5, 10, 15 years later, where, in this case, we don't even have a plea colloquy, which some of the cases that were cited by both sides rely on to make a factual merits determination. And we don't have a plea colloquy. He did not do a motion to withdraw plea. He did not file a direct appeal. The plea colloquy was never transcribed. So if he brought this 10 years from now, and that plea colloquy could have been dispositive about this issue, we wouldn't have it because, of the way the process works and how things are lost and things are destroyed, papers are destroyed, and judges aren't there anymore, and prosecutors and defense attorneys aren't there anymore. If there was an understanding at that time that there was no question that the Office of Statewide Prosecution had jurisdiction, 5, 10, 15 years later, the result might not have been as clear.
Assuming that the information really was problematic, that it only went to one county, not multiple jurisdictions as it should, under those assumptions that there was a true problem. In that case, instead of a claim for subject matter jurisdiction, wouldn't it really be personal jurisdiction? Because the argument would be that the defendant would say, look, I'm being held into court here and I shouldn't be here. Not that the court itself doesn't have jurisdiction, but these people do not have the authority to bring me into court under these charges. So isn't that a personal jurisdiction
Yes,
argument?
it is personal jurisdiction.
It has to be raised timely,
Yes, I think.
unlike subject matter jurisdiction.
Yes, the personal jurisdiction can be waived also. There's plenty of case law on that, and it should be raised in a timely manner because it can be fixed. And if you look at it like, if he had been arrested, let's say in Collier County, and some of the events occurred in Lee County, and he said, well, I'm not supposed to be in Collier County, I'm supposed to be in Lee County, well, then you're looking at, well, the court still had jurisdiction over him, the circuit court still had jurisdiction over the actual cases, but they were in the wrong county.
Well, maybe you've actually, and by saying what you said, I think you said something important, that it should be raised timely because it can be fixed. And to me, that probably distinguishes some of the cases that we are talking, or the hypos. Statute of limitations ran, can't be fixed. The probationary period ran, can't be fixed. And these are things that ostensibly appear on the face of the record. So I think that, to me, that's what distinguishes those hypotheticals from this case, is that not only could it have been fixed, but it probably didn't need to be fixed because there was probably not a problem to begin with. But if there was, the only thing that would happen is there is superseding information, right, by the Lee County prosecutor.
Yes, that's exactly right. That's exactly right, Your Honor.
What about the circumstance where there's a distinction between the felony and a misdemeanor? And now that could be fixed.
I agree with that. I do think they can be fixed.
I mean, and isn't that really the clearest sort of purely jurisdictional distinction that has entered into this discussion? But that's something that could be fixed.
I think it can be fixed. I mean, I don't want to go contrary to all the law that's out there that it's subject matter jurisdiction, but But
what I'm saying, if that was brought up at an appropriate time,
yes,
it would just be transferred from the circuit to the county court, and
or the county.
If it was raised properly, it's something that is correctable easily.
Yes, and if you look at the cases such as Lugar and Winter, they did file motions to dismiss. It came on appeal later, of course, with other issues, but they did file motions to dismiss in the court. And the court was able to make factual determinations, and the trial court was able to decide whether the motions to dismiss, decided against the motions to dismiss because of the facts that it had before it. And in this case, what you have is a easily fixable information that was filed by the Office of the Statewide Prosecutor, and the defendant in this case did not file it within the 2-year time period allowed for in Rule 3850. Thank you.
Thank you.
If we're talking about fairness, first of all, we have to look to the situation where every litigant in a Florida court, every single litigant, no matter the type of case, can bring a subject matter jurisdiction challenge any time. A court can bring it any time.
Why isn't this really a personal jurisdiction claim instead of subject matter?
Because this goes to the authority, the power of the statewide prosecutor to bring...
That's not the subject matter jurisdiction we're talking about. We're talking about the subject matter jurisdiction of the circuit court.
The subject matter of the jurisdiction of the circuit court is initiated by the prosecuting authority. Therefore, the prosecuting authority must have subject matter jurisdiction over the matter.
Why is Justice Polston's question then personal jurisdiction? It's because they don't have the power on this particular, as set forth in this piece of paper.
Just like in a civil case, if somebody came in, they don't have sufficient contacts and so forth, they don't do business in Florida, whatever, but yet they're brought into a Florida court, and the argument is, hey, you don't have personal jurisdiction over me. You don't have the right to bring me into this court. Same type argument here. Statewide prosecutor, you don't have the authority to bring me into this court. That's not a subject matter jurisdiction argument. It's personal jurisdiction.
But that's not what happened here. What happened here is it was in Lee County. Everything was in Lee County. It just wasn't initiated. That court never got the power. That court never got the jurisdiction because that has to occur by the statewide prosecutor getting the power, getting the jurisdiction from the Constitution. There has to be a grant of that power from the people, or else there's no authority for which the court can be acting.
So prior to today, several years ago, only the state attorney, not his or her assistant, could find information. So if an assistant filed an information, that information was in fact filed in the court, was that the subject matter jurisdiction of the court?
I see my time has expired. May I have a moment to answer the question?
Yes, please answer.
Okay. That goes to the defect in the information, whereas later on in the case, the facts are fleshed out and the facts demonstrate that there's jurisdiction. Here, the facts demonstrate in the record.
I don't see how that's any different if the assistant state attorney did not have the authority to sign the information. Why is that any different from here, where you're basically arguing that the statewide prosecutor didn't have the authority to sign the information?
Well, in your case, it's presumably later demonstrated that that authority did in fact exist. There you're talking about
I'm talking about a situation years ago when only the state attorney had the authority to actually sign the information, as opposed to an assistant state attorney filing the information. So you would say that was the subject matter jurisdiction of the court also?
If that was never properly invoked and shown to exist. Now, in that case, I'm assuming that jurisdiction did in fact exist. Here, jurisdiction does not in fact exist, because here, although the information does ostensibly allege that the general allegation that tracks the language of the statute, 2 or more circuits, but when we look at the record, we can see there was a mistake made, that it wasn't 2 or more circuits, it was 2 or more states perhaps, and there's this tangential activity, this assumption that the drugs are going to somehow be tracked through Florida on through multiple circuits. Well, first of all, that's not multi-circuit activity. They've conceded that there's not 2 or more related transactions. Second, that doesn't affect.
So if they in fact got drugs from Mexico and came across and went through before, what county was this?
Lee.
Before they got to Lee County, they came through Hillsborough and Sarasota and Manatee and all of that before they got to Lee County. Would that be sufficient?
Well, they've conceded there's not more than 1 related transaction. Rather, they're proceeding under this idea of affecting 2 or more circuits. So yes.
And if the drugs came into the state of Florida, and let's even start with Lien County, down through all those counties that you go through before you get to Lee, is that sufficient?
No, because that's absolutely not showing that these other circuits were affected. And as some of the case law has shown.
How about if I stopped overnight?
Is that affecting the circuit? I mean, there's a case that addresses this question in the context of a bank account, an account that was, there were holders of this account, and this account was compromised by the alleged actions of the defendant. And so these people throughout the state have a stake in the account. Well, that case held that it wasn't enough to show that those counties, that those circuits were affected. And certainly traveling through is not going to affect those circuits.
Well, what if there was a traffic stop and they were arrested? Could they prosecute them for having the drugs?
I'm sorry?
If there was a traffic stop and they discovered the drugs in the vehicle while they were traveling through, could they be prosecuted? Well, that would be
then where the transaction, under the language
but
of the...
where's the transaction? I mean, they're just driving, and they get stopped for a traffic ticket.
Well, the transactions here that have been alleged are the ones that took place in Lee County, and there's no dispute about that. And so we'd respectfully request that this court reverse with instructions to remand for reversal of the judgment and sentence as well, and contingently, if this court finds further fact-finding is necessary, that it be remanded for an evidentiary hearing. Thank you.
Thank you. Thank both sides for your argument. I'll move to the final case on our docket today, Rashkind versus Michella. Please proceed.
Thank you. May it please the court, my name is Robin Breeski, and I represent the petitioner, Robin Rashkind PA, and here with me is petitioner and co-counsel, Robin Rashkind. Briefly, the facts of the case. Just to reiterate, there was a contract between Rashkind PA and Ms. Michella. Rashkind PA ultimately withdrew and subsequently filed a motion to adjudicate a charging lien. The trial court denied the motion based on the fact that there was no expert testimony that could corroborate a reasonable fee. We appealed to the 4th District Court of Appeal, which certified this as a matter of great public importance.
Tell me what the state of the law is. What circumstance expert testimony is required to right now in the state of Florida? If it's Chapter 61, one party against the other, is an expert required in those situations?
And that, pursuant to Chapter 61, it's determined on ability to need an ability, and an expert is not required.
But what about for the amount? In
those situations, to determine the reasonableness of the amount, sometimes the expert is required.
No, is it? I'm not saying is there a case law that says when somebody what I consider to be outrageous fees that parties to litigations, the attorneys charge for what they're doing, and one comes in and trying to get fees, is it required for reasonableness that there be an attorney to testify on behalf of the party that wants the attorney's fee?
Not, in my understanding, not under Chapter 61. However, I think that's a lot of what the confusion really is here. It seems that some of the case law says when it's a third-party payer that there is that requirement. It seems a little bit confusing, quite frankly.
Well, what I want to ask, in the
is.
real world, yesterday we had a case and we talked about the real world. What I understand happens in these divorce cases, primarily, probably these other cases, is that someone asks for a fee, they ask for, say $750 an hour, and they talk about that they spent, thousands of hours, and they come and they talk about that, and then they get their friend, or they get, to come in and say, oh yes, Miss Pariente she deserves every bit of that $750, and all those amounts were reasonable. Is it basically, to me, and rather than it, and this is a friendly question, rather than being something that should advance public trust in our system of justice, this has almost become a system to degrade our system of justice, where one person comes in and just supports an outrageous fee.
That's exactly my argument.
I mean, but that should be then Chapter 61, same thing. I mean, this idea, now maybe I think when you have cases involving the multiplier, you have these situations where you've got to figure out, could somebody have gotten other attorneys, and where the court may not know it. And of course, nothing precludes you from bringing an expert in, but the idea that we would require somebody to bring in their friend to mouth whatever they're going to say, I don't see how that fulfills any purpose.
Have you ever?
Do you agree with that?
I do agree with that, absolutely.
In your experience as an attorney, and this has been my experience in presiding over these type of cases, have you ever seen a situation where a lawyer came in and testified that the amount sought by the counsel was not reasonable and necessary?
Not the expert witness that attorney brought in. No.
That has never happened in your experience.
I've never seen that happen.
I've never seen that either.
I've never seen it. It is always, and that's really the point here of the case, that the law has outlived the usefulness.
Wouldn't it make more sense if there were a need for an expert, that the court would appoint one, making him the court's expert? Wouldn't there be more credibility there as opposed to having dueling experts who will testify to whatever their side?
Yes, I think that's absolutely correct. And in fact, if the one party feels that, let's take for example the contractual relationship here with the client and the attorney in a specific narrow instance, if the client feels that it is unreasonable. We submit that the onus should be on the client to bring an expert to say that it is unreasonable, that it shouldn't be, that basically it should not be just a rubber stamp of bringing somebody in.
Well, in this case, help me make sure I understand that this contract, and I've never seen one that allows these kinds of things, but so be it. I mean, I guess I learn every day. But it came in on withdrawal and wanted a lien and established it really not with an evidentiary kind of thing, but was even the client there?
At the hearing?
Yeah.
The client was present at the hearing, yes.
And did the client have a lawyer there with her?
Yes, the client had
a separate lawyer.
Had a separate lawyer.
And that lawyer didn't question anything about this fee or structure or the reasonableness of it or the necessity of it?
I'm sorry, I misspoke. There was a lawyer representing the Rashkind firm. There was not a lawyer representing.
That's my point. That's my point. I mean, why should we rubber stamp something like this? And to me, I guess that's why I'm not rich. I never, ever in my entire experience have ever seen a contract like this and a proceeding like this. And when a lawyer's discharged for dissatisfaction, that somebody comes before us and says we should just rubber stamp this no matter what.
You're saying rubber stamp the agreement?
Well, rubber stamp that this is what it was, and that's it, and this is the bills I sent, and you didn't object, and so this is it. You're out. You're out. Here's the lien. There's the amount.
Well,
whether that's reasonable, whether that's necessary, and you got a client sitting there, the public, who doesn't know.
Well, I think that you have to look at what value is added by that expert coming in on behalf of, in this case, the attorney, and testifying that it's reasonable.
Well, I tell you, contrary to my colleagues, I find that lawyers will tell the truth if somebody asks them the question. Is this how much that you would charge for doing that? And I've seen experts say, no. Answer the question. Have you paid clients for TV sets as part of the costs that they're claiming here? No. I have seen lawyers come in as officers of the court who are concerned about their reputation that will answer truthfully. If we're to assume that everybody comes in is just going to prostitute themselves and lie, then you're right.
I agree with you. You can't assume people are going to come in and lie. But the fact of the matter is, the attorney is responsible for bringing in that expert, and the attorney is going to, and this is how I believe it happens in practice, my experience, the experience I understand attorneys have, you need an expert witness, you go to an attorney friend and you say, will you look at this and see if this is reasonable?
Well, that's true, but you have a proceeding where on the other side, the client at least gets the opportunity with a lawyer to contest what's going on. I mean, I just don't understand how this happens, not in our system today.
Well, respectfully, the argument, I think, is not that it shouldn't happen if there's an unreasonableness. If, in fact, she's saying that it was unreasonable, if, in fact, that the client is saying that it isn't unreasonable, we are not saying that they're precluded from bringing in somebody to say that. We're simply saying that there's no value added to having somebody come in who's a friend.
Oh, I understand. Yeah. I understand that what you're saying.
And, in fact, to take it a step further.
That doesn't make it true necessarily. Just because somebody says it doesn't necessarily make it true. Because I would hope, and I'm concerned that we would say that lawyers come in and lie just to help a friend, because that really is saying our profession is really sick. That's what you're saying.
Respectfully, I'm not saying that anybody's going to come in and say and lie. I'm not saying that anybody's going to lie.
You say we don't need them. We don't need them to come in because they're not going to answer questions on cross-examination. They're not going to be truthful. They're just going to. They just come in and support what the lawyer who asked them to come says.
I believe that they're not going to come in and just say it and lie. I believe that the lawyer who asked them to support it is going to find someone who truthfully agrees with what they're doing is appropriate. And then on the other side,
can I ask you about analogous context of other professional services?
Sure.
Accounting services, medical services. What are the rules there with respect if when there's a dispute over a bill and a professional sues? Does a physician or an accountant who sued a client because the bill hasn't been paid have to bring in an expert witness to testify to establish the appropriateness of the charges? Or do you know?
I don't know definitively, but I assume if you're going back to contract principles, as we do in all other areas, we say you can have a contract that's the benefit, you get the benefit of the bargain. Just because it's not a fair contract, it doesn't mean it's not something that you bargained for. However, in the case...
Well, in a lot of circumstances, I would assume that there may not be a written contract. It may be more like what the usual and customary charges are. Sometimes there might be, but whether there's a contract or not a written contract, I'm asking because this is an evidentiary burden that is placed on attorneys who are seeking to collect fees, and I'm just trying to find out if a similar evidentiary burden is placed on other professionals who are attempting to collect fees. And and I don't think that's addressed in the briefs, and if you don't know, and there's not case law.
Right, it's not addressed in the briefs, but I don't believe that it is similarly addressed. However, I will say we are not saying, the argument is not that the fees shouldn't be reasonable. Certainly, we have a
I certainly didn't mean to suggest from my question that you were.
Sure. I just wanted to sort of segue in and move on to the fact
Well, before you move on, let me see if I understand exactly what went on here. Because she didn't pay her fee, the attorney filed this charging lien action, and it was set for some kind of hearing.
Correct.
And both the attorney and the former client were noticed that this was a hearing about the fees, correct? And so the former client came to the hearing without an attorney.
Correct.
But had an opportunity to bring an attorney.
Correct.
And so in a normal charging lien case, would the judge simply go with the fee that is in the fee agreement? Or is this case outside of the norm and asking the attorney to have some expert testimony concerning the amount of the fee?
Well, what the fourth DCA said was...
I mean in ordinary circumstances, right. That's my real question. In other circumstances, do you normally have to have an expert at a charging lien, or do you normally just go with what is in the contract?
Quite frankly, I think that's part of the confusion when you say normally. I think that many times people do bring in an expert to substantiate, because there is this idea if there's a third-party payer that you need to have an expert. It's sort of carried over to...
Who was the third-party payer
Well,
here?
not in this case, in other contexts. But what I'm saying is, when you're asking me, does it normally happen? I think, and as a matter of practicality, yes, it usually happens. But what we are saying is, that's not useful, and what it is in fact doing, it is increasing the fees to the litigants.
Well, normally in charging lien cases, you have attorneys fighting over a fee, right?
Correct.
One law firm against another law firm, so you got an opposing party who can come in with an expert to contest whatever's being put on.
Correct.
In support of the fee. But in this case, when you're dealing with a client, it seems like a different circumstance.
Right, and the different circumstance here is that the client has agreed to this contract, and just as the fourth DCA mentioned in Franklin and Marburn PA versus Mascola, it's really the contract principle that controls, and in that case, they disregarded the expert witness testimony.
So if they disregard, if they're free to disregard, then in this case, could the judge, after hearing that this was, I don't know, $65,000 worth of a fee in 6 months, I mean, have said, I'm not going to allow the fee, but I don't think this is reasonable. I think this is an unreasonable fee, that there was churning in this case, or whatever it is. Can the judge, on his or her own, evaluate this based on his or her own experience?
Absolutely, and in fact, we submit that the judge is more qualified to do this, and very often disregards the expert testimony, and that is why there is no value added to this expert testimony.
And
because
as far
it can be disregarded.
and as far as this issue, because I am very much Justice Lewis and I may disagree with how we're characterizing what these experts in these kinds of cases do. But as far as this issue as to whether there should have been an ability to claim the entire fee, or whether there should be quantum meruit, all those issues should be able to be litigated as to whether this is a reasonable fee.
Yes, we absolutely agree that those issues should be litigated. The simple fact of the matter is the expert witness that the attorney brings in, again, does not add the value and, in fact, harms the litigants overall.
How does that do it? How does that occur?
Because the very thing we're trying to do by saying, if we're saying we don't want an excessive fee, and, the rules that the Florida Bar has come forth, 4-1.5, illegal, prohibitive, clearly excessive fees, we obviously want to make sure that that's not happening. But
to see that that's not happening, you don't want an expert to come in and add a couple of $1,000s to an otherwise outrageous fee.
Exactly, because...
Well, how about, you've got judges that rotate. In fact, members of this court want to insist on rotation. And Justice LaBarga, let's assume, never was involved in a domestic case. Always was a state attorney or a public defender, went on the bench, and was assigned to criminal division. The first day he's assigned to the civil division, he's got this case. And I would think he would say, you charge administrative processing fees on top of a $400 fee. You charge this amount for a paralegal that doesn't even require a college education. And so he has no place to test that.
I believe that he can then rely on the attorney's testimony. And
certainly you can always do that.
Right, and I don't
the question
believe that
is, do you add any value by having someone there who maybe has an ounce of honesty in them to respond truthfully to a judge? And to sit and say, well, it doesn't add anything.
Well, no, I
don't know of any lawyers in Dade County that charge to come in and act as a witness. So it doesn't add costs on top of costs. You do that for the bar.
Respectfully, unfortunately, I don't know of any attorneys that don't charge to come in and
maybe your generation ought to look back to what some of the older lawyers used to do. You do it as a service to the court, as a service to the bar.
I agree that's a lofty principle. What we're arguing is that's not what's happening in reality. And in reality, it is adding fees and it is adding taxable costs to the losing party, the client. Let me just say...
I just want to let you know you're now down to about 2.5 minutes of your overall time, so you're well into your rebuttal.
Thank you.
But could the trial judge have said, instead of saying, I'm not going to give you this because you didn't bring an expert in, could the trial judge have said, look, I'm concerned about the outrageousness of this fee. You bring in an expert.
Yes, that's exactly correct. The trial judge can always say, we want to hear testimony. We need an expert in this particular case. And the client or the other party can always bring in an expert to say it's unreasonable. We're just saying the onus should not be on the attorney to bring somebody in who is likely not going to add any value. And just very quickly, we submit to the court, it's better to look out for the interest of the litigants in reality than it is to hold on to some false perception.
Let me just go back to your value thing. It could add value, but going back to what Justice Kennedy said, the question is it an evidentiary requirement necessity? And I think that's where we're missing the boat. There are people, and they would add value to an evidentiary hearing and make it, whether it was an accountant, an attorney, or a doctor, and give the judge more information. The issue here, I thought we're talking about, is it an absolute requirement that without it, you can't go forward? Isn't that what we're really, isn't that true?
Yes,
so
yes.
To say it's never has value, I think is a gross overstatement.
And the issue on top of that is truly, it's a judicially created rule.
Yes.
It's not an evidentiary in the true sense. But at one point in our state's history, the judicial branch felt that it was important enough that we have that. And so now what you're saying is that it's not important enough to have it. It's not that we all recognize that it was not part of, like doctors don't have to bring it. Justice Kennedy, I asked you the question you didn't know. Of course you do not have to. You may, but you do not have to.
You don't have to have it to substantiate.
But the judicial branch decided, and all the reasons. So when you keep arguing no value added as the only reason that we should abrogate that kind of rule.
Well, in reality, let me just close by saying the harm to the client is more likely to result from what I see as a self-serving practice now in our profession of charging litigants for expert witness testimony that does not truly shed reasonableness on the fees. It's not just there's no value added, but that there's harm created by this rule, by this what the Fourth DCA has basically said in other cases, the antiquated rule. Thank you.
You have used all your time. I'll still give you a minute for a succinct rebuttal.
Thank you.
Please the court. My name is Blake Paul, counsel. I'm with Peterson and Myers out of Lakeland, Florida, and I represent Belinda Michella concerning whether or not expert witness fees ought to be required or continue to be required in Florida in order to support an attorney's fee claim.
Now, could you answer the question for me? If this had been Chapter 61 and Ms. Rashkind had continued as the attorney and now was seeking to obtain the attorney's fees from the husband, do you do family law?
No, I don't, but I am familiar with the issue that you're asking
okay.
about.
Is it required as to the reasonableness to bring in an expert?
No, there are actually 3 exceptions to this rule that are all statutorily created.
Statutorily created?
Statutorily created. Chapter 61 says that you do not need to bring an expert witness in when, say, the husband is seeking fees from the wife.
So that's the legislature decided, despite all of this, that there is the belief that this court had that attorney would only be self-serving, that actually they made a policy decision evidentially that it's actually not required.
Yes, and that's part of my argument here today, Judge, is that the legislature has made specific findings vis-a-vis attorney's fees,
but they
and
didn't.
What is and what is not reasonable and when an expert is required.
Okay, so that's number 1, quote, exception. What's number 2 exception?
The other 2 are essentially one exception. They are 2 statutes, Section 702.065 and Section 687.06. These statutes set thresholds for attorney's fees in mortgage foreclosures and promissory note cases. In other words, as long as the attorney's fee does not exceed 3% of the race, then it is deemed reasonable, and therefore you do not need an expert in those cases.
Now, this is an issue not of whether the fee is reasonable in this case, and there is plenty of reason to argue that maybe this fee was unreasonable, and I don't know if that was one of the issues raised on appeal. The question is, and I will reiterate, charging for your assistant, your secretary, it's just, maybe that's what's done now, but it just sort of seems incredible to me. So I have plenty of concern here. But in terms of the integrity of the proceeding and the necessity of having to bring in an expert or you lose, tell us, and the rule that was established 30, 40 years ago, how is that rule still viable, important, and something that this court should reaffirm when the same attorney who, if they hadn't withdrawn, was seeking fees against the husband, wouldn't have to bring in an expert, actually has to bring in an expert to establish the fee that they are owed up to that point?
The rule is important for several reasons. Number 1, the rule was established in 1964 in the second DCA in the Lien case. The rule has been developed by the bench and the bar in an effort to self-police attorney's fees.
Now, let me ask you this question, and again, I don't want to, Dade County may be different than Palm Beach County, and I haven't practiced for a lot of years. But my understanding is when I left Palm Beach County, I have friends continue to practice that in this area, it really is they may do it as a favor. They look and they say, yeah, I can testify to that. And it is, how does that, if that's what's essentially going on, how does that make it a necessity in order for a trial judge to reach a decision on the reasonableness of a fee?
There are a couple of reasons. Number 1, I'll answer that question with my own experience. I practice in Polk County, have my entire career. I also practice in Hillsborough, Hardee, Highlands, and all the surrounding counties. And my experience in those surrounding counties is that, one, lawyers testify for other lawyers as a matter of professional courtesy gratis. Only the very complex cases are an exception to that general rule. Number two, our firm does a significant amount of eminent domain work, which means that we litigate attorneys' fees a lot. And we have to go before the court and routinely present expert testimony regarding those fees. And oftentimes, the expert that our firm hires comes in and has critiques about our bills. And so, my practice being what it is, that leads me to a couple of conclusions. Number one, the expert witness provides protection to the lawyer that hires the expert, that brings the expert in.
But there's nothing in any of this that the 4th District has talked about and the 5th District has talked about that would prevent a lawyer from bringing in an expert.
That is true.
Okay,
and
so that's gone, because it's certainly, I would, as a conscientious lawyer, I'd want to bring in an expert myself to make sure that if I'm attacked, that I have somebody else, and I'd bring in Justice Lewis or Justice Labarga to hopefully back me up. And if they said something in my bill looked fishy or not as documented, I'd either document it or not claim it.
Right.
So I think that's a good protection for the lawyer.
And that is an added benefit across the board. And I'll talk about in a few moments why that's an added benefit and why it's important for purposes of making this and retaining this as a rule across the board. You're correct. This is a substantive rule of evidence. It is a modicum of proof that is necessary to make a prima facie case. As with all expert testimony, the trial judge isn't bound by it, but it is a modicum of proof under the Lyle decision and under the 4th DCA's
But it's not a substantive rule of evidence. It's a judicially created rule that has no basis in the rules of evidence.
Yes. And
is that correct?
Perhaps I misspoke. It has a basis more in public policy than anything else. And so, as I said before, it protects the lawyer that hires the person.
But we're not here in the business as judges of trying to protect the lawyer that's trying to seek an exorbitant fee from the client or a reasonable fee. That's not our job. The Florida Bar, if the fee is excessive, they prosecute. If the defendant, if the person who's being sued, they can be defend in court. But we're not here to help the lawyer make sure that they can get the biggest fee from their client, are we?
No, and I'm not asking the court to protect the lawyer. What I'm asking this court to do is to protect the independence of the judiciary. Because if we do not find a way to self-police our attorney's fees, and this is one way to do it.
Well, why don't we just say that in these cases, that a fee over $250, if you're going to claim that, has to be testified to by 3 attorneys, one, as Justice Perry said, an independent court-appointed expert, and have that be the rule, that we say nothing over a certain amount can be sought in a domestic relations case. Wouldn't that be better? I mean, the fees that are being charged, at least in South Florida, are exorbitant, in my view. They are out of proportion. These cases, and despite the matrimonial lawyers' attempts, it doesn't seem to be getting any better. Wouldn't that be better? Why don't we just have a set fee?
Well,
why does the legislature set the fee?
Remember, if you are referring to attorney's fees awarded to the husband from the wife or to the wife from the husband, remember, those fees are not subject to expert testimony according to Chapter 61.
Well, that's all the more reason that this is dealing with something, this particular situation is dealing with just a little tidbit of the bigger problem. And the fact that you got to bring in an expert in this situation when, let's say you've been fired and you don't, if you continue to represent the person, shows to me the illogic of the rule in light of now this subsequent Chapter 61 amendment. It's not doing what it was designed to do, because the legislature decided that self-serving testimony would be fine.
Well, and the legislature decided that self-serving testimony would be fine, and under your example, attorney's fees awarded against a husband or a wife have gone up. And so my argument would be that the legislature's cure of eliminating expert witness didn't work.
Well, then go over to there and tell them what else they need to do.
It seems like to me that your best argument is that in this case, you've got a client and that the interest in protecting the client would call for the use of an expert in the reasonableness of fees. Contrast it to a situation where you may have law firms fighting over a charging lien or other circumstances in which you have attorney's fees being sought against another party, in which you have the adversarial system bringing to bear the use of experts going at it in the battle of experts, as usually done in our cases, to contest the amount and reasonableness of the fees. But in this case, it seemed like a different circumstance where you have a client who's dealing with their fees and the reasonableness of that. So it seems like a better argument, to me at least, is that this is a protection of the public or protection of the client themselves from the fee.
Yes. And that's what we led off with in the brief, Your Honor, was that when the lawyer signs the contract with the client, the lawyer is the client's fiduciary. When the lawyer is representing the client and running up the bill, the lawyer is the client's fiduciary. And when the lawyer comes to court to ask the trial judge to bless his or her fee, the lawyer remains the fiduciary, perhaps no longer representing the client, but the lawyer now is not only the fiduciary of the client, but the lawyer is a fiduciary and an officer of the court.
So wouldn't a better rule be that in that situation where you have a client who's unrepresented, as happened here, and you have as the trial judge a concern that this fee seems out of proportion or the fee agreement seems unreasonable, to say, I am going to appoint an independent expert? Is there anything, because I think you've raised, I think this is a good point, that this is a concern. Wouldn't that be the way to regulate that situation when you don't have, when the person's not represented by an attorney on the other side, so they didn't bring in their own expert, or they don't know how to cross-examine, so they presumably won't be able to cross-examine the expert brought in by the attorney to buttress their claim, to hire somebody who, or court appoints its own expert to look at this, because I'm concerned with it. Why isn't that a bit, if we're going to be playing with the rules, why wouldn't that be a better rule?
The problem with that rule, Judge, is it relies on the discretion of the trial judge to decide when he or she needs an expert and when he or she doesn't. And
But we do.
Isn't that where it ultimately stops anyway?
It does. And the
when I was a trial judge, I had domestic cases, and attorneys came in with exorbitant fees, whether they had an agreement or not. And I said, you got to be kidding me, right? I mean, $1,000 to depose the tree, the dog, the cat, I mean, they're just churning fees, and I simply wouldn't approve it.
The problem that we have with relying on each individual trial judge to decide when he or she needs an expert and when he or she doesn't is twofold, really. One is consistency. Because remember, the primary reason that the second DCA gave for originating this rule way back in 1964 was the public perception. And so now we've got
public perception of lawyers?
Public perception of lawyers and the judicial system itself. And now you're going to have
Okay, so you can help me solve the public perceptions of lawyers? That's what you're telling me?
What I'm telling you is this rule is part of the milieu that's necessary to help that process, Your Honor, absolutely.
Maybe the better thing would be for the Florida bar to get involved in regulating these kinds of things, just like they got involved with contingent fee contracts. Why don't they get involved in regulating the kind of fees that are being charged in fee agreements in dissolution of marriage cases when clients are at their most vulnerable. But going back to this idea that discretion is we shouldn't allow discretion. But what Judge Gross said in one of his concurrences is the fallacy with all of this is we say that the judge, the fact finder, has discretion to disregard all of it. So we've given the judge the discretion to say, I don't buy, just what Justice Perry said, and the good judges actually, whether they've just gone on the bench or they've been on for a few weeks, they get the game, and they are able to, in places, put a stop to some of this and say, no, in my courtroom, in this court, something that is over $350 an hour or whatever it is, $250 an hour, is not a reasonable fee. You want to take me up to the 4th District? Take me up there. But that's how we got to go. If the judge then, the only way the judge is going to be able to do that is have someone back him up on the other side. So again, I say that if the judge says, you know what, I know that Fred Lewis is always somebody's a straight shooter, and I'm going to call Fred Lewis as my own expert to come in and evaluate this, because this client needs protecting.
The problem with relying on the discretion of the trial court is exactly what you described, which is the appellate process. The standard of review on appeal is abuse of discretion. And so if the judge decides, I need an expert, or I don't need an expert, and he decides, I don't need an expert because I know what reasonable attorney's fees are when I see them. The trial judge's experience at that point now becomes very important, and is not part of the record.
But you're acting as if they
You just said if you require an expert, the judge can discount and not even consider it anyway. So I mean, you're going to create a rule. I don't quite understand how this rule should be promulgated to ensure that judges have no discretion.
Well, the rule exists today. Right now, if you seek attorney's fees, other than in the dissolution proceedings, which proceed under Chapter 61, breach of contract. I have a contract case against a defendant. I win. The contract says I get attorney's fees. If I go and pursue fees against that defendant, I must bring an expert with me as part of the modicum of proof that is necessary for me to make a prima facie case. That's the status of the law right now, and everybody essentially agrees with that, including the Fourth, which has been very vocal in criticizing the rule.
Let me ask you one thing that I find troubling is I know you said at the beginning that you do not practice in family law, correct?
Yes, ma'am.
But do you know enough to tell us whether or not this is a standard kind of contract in these family law situations? It seems a little draconian to me.
Well, and this is why I detailed the contract in my brief, because this is, in my view, from a contractual standpoint, a worst case scenario as far as why we need expert testimony, because the expert helps the lawyer who's hired the expert self-adjust. The expert helps the judge have a justification for where he's going to go, he or she, especially in a state that has exploded in population. Since 1964, our state has tripled in size. Since 1964, our bar has quintupled in size. We are more specialized as lawyers. We are more specialized as judges. And I can't remember who mentioned it earlier, but this court is even in favor of judges rotating around. And so a judge may be in the criminal division, felony division for years and never have anything to do with attorney's fees. His first week on the job, he's stuck listening to an attorney's fee issue.
Let me ask this question. Although you don't do matrimonial law, you do other litigation?
Yes, sir.
Do you enter into contracts for fees with clients?
Routinely.
Have you ever seen in your legal practice a contract such as this at $400 an hour, discount, paralegal charges, secretarial charges, 10% administrative overhead charges, plus all the others, then a charging lien that you can't even contest according to the contract what my bill is, and I get a charging lien against you? Have you ever seen?
Not until this case, Your Honor. But the point...
And let me go back to that, because if you haven't, and here's the problem, and you're making very good points, you're arguing professionally, and I appreciate your insight on this. But we go now and we're back down to Palm Beach County, and someone comes in and say it's a lawyer that charges actually $700 an hour usually, and there are lawyers down there that unfortunately do that. And they say the same thing. How has the process, how is there more integrity? If the judge isn't cross-examining the initial lawyer on it, if the other side doesn't have a lawyer to be able to cross-examine, I don't see where the integrity of the process is helped. That's why I say, isn't it better served if there were to be a rule to say that if there's a fee over a certain amount or a certain that an expert should be called by the court to advise the court on what standard and all that?
Certainly that rule is available, but I think that the expert witness, as I said before, provides another set of eyes. And I'm a bit of an optimist from that standpoint, maybe cockeyed in that regard, in that in my world where I practice, the experts that I've hired myself have come to court and told the truth. The experts that my partners have hired themselves have come to court and told the truth about what they feel about the about the attorney's fees. And I think
but you don't think Ms. Rashkind could have gotten an expert in Palm Beach County to say that these are standard contracts in Palm Beach County? I mean, do we have any record that would even suggest that?
Perhaps, I do not know whether they could have not. I can only assume that they could have. But I don't think that we ought to throw the baby out with the bathwater here. I don't think that we ought to abandon. This is a rule, as I said before, it's been developed over 4 decades in order to self-police attorney's fees. If we don't find a way to do it, and there are a number of other ways to do it. Some of you guys have probably read the article that came out in the Bar Journal that I think was in both of these appendices, at least cited in the briefs. There are a number of ways that the court, in its rulemaking position, can deal with this issue. One way would be, if you are going to seek attorney's fees, you must send a detailed bill to the other side showing what you're seeking. In a certain period of time, they must come back and say, that's not reasonable, this is reasonable.
Well, then
the parties know what
that happens now, doesn't it?
Summary judgment process is used all the time to deal with these and other contract cases.
That's right.
That's exactly how that gets done.
And if you know what you're fighting about, instead of $60,000, I think $40,000 would be reasonable. Now we know what we're fighting about. We were fighting about $20,000. Is it worth going to an evidentiary hearing at that point? So there are other procedural mechanisms that the court can use other than abrogating 40 years of law on this particular subject, which we do not believe would be appropriate, especially given the fact that this was the substantive law that Ms. Michella walked into and was the substantive law of the 4th DCA at the time that she had the hearing. So we would request that the court affirm the 4th DCA.
Thank you. Opposing counsel took about 2 extra minutes, so I'll give you 2 minutes also.
Thank you very much. I just want to make it clear, we are not obviously saying that clients should not be protected. We are saying that this mechanism is not doing what it purports to do. And as far as holding the image of lawyers, in a better regard for the public, we are arguing that it's doing the opposite by contributing to increasing the litigation fees, to increasing the costs, which are taxed to the losing party, in this case, the client. And in fact, that is really the harm. They're being harmed more by something that is not helping them, but that is harming them. Again, I think that the fact that a client thinks that something is unreasonable, if the judge thinks it's unreasonable, obviously the judge can make that call. That's how it is right now. The judge could require an expert to come in. The client, if they think it's unreasonable after they have agreed to it, should be able to have the burden and the onus saying, this is unreasonable, I'm going to bring my expert and tell you why.
Do you practice in Boca Raton?
Yes.
Just like we asked the other side, are these contracts is this the standard contract in Palm Beach County?
Well, I do specifically appellate work, so with regards to the contract for family law attorneys, I don't know. I conceitedly, I think that this is a little bit more you know, a little bit different than what I think takes place. But again, an expert witness, we don't think would have helped the problem that comes into testify.
Wait a minute, you do appellate work?
I do.
In the civil arena for
Yes.
domestic cases?
Yes?
You represent to the court that you don't know what contract fees are in domestic cases in Palm Beach County?
No, I represent that I do know the amount of the fees, but the way that this one was structured.
No, that's not what was asked. Is this a standard contract Palm Beach County that you have seen as an appellate lawyer?
No, it is not a standard contract that I have seen such as this. But my point is, I don't see the contract phase that often, is what I was saying. Basically, we are simply saying that we feel that the case should be, the trial court's decision should be reversed of 4th DCA based on their own comments that this has outlived its usefulness, and in fact, in this narrow circumstance where somebody has contracted with an attorney, that this is at least a circumstance to say an expert witness testimony is not necessary. We respectfully ask that this be reversed. Thank you.
Thank you. We thank both sides for your argument. That's the last case of the day. The court will now stand adjourned.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.